Yes.
My lord, may I beg one indulgence? Though I should not mention this is an appellate side matter. 16
Appellate side matter we take up mentioning when we take up the appellate side. Please come back at when
at
we take
2 p.m.
At 2 p.m. we take up
All
either 2
all
or
right,
whenever
all
this.
right, my lord.
I also same.
Please come back whenever the appellate side matters. Or send somebody when the
My lord,
appellate.
only thing, my lord, the 16 appellate is a very interesting point of law because I am here
Definitely.
before my, no, that is my privilege to
When you
appear
mention,
before
we'll
my
hear
lord.
it. Yes.
This is a pure question of law.
When it is
And
mentioned, we'll hear. Yes.
Yes, I will come. I will come.
Yes, call on the list.
Sorry.
Original side, no mentioning. Yes, then call on the list. Yes.
Appellate side one mentioning, my lord.
No. Call on. 4 বার করে বললে যদি বাংলা ইংরেজি দু ভাষাতেই বলতে হতো তো ইউ আর হিন্দি স্পিকিং অর বেঙ্গলি ইউ আন্ডারস্ট্যান্ড ইংলিশ
I just
come in time within time before court sits. Yes, call on the list. Yes.
My lord, may I start, my lord, till
Yes.
Mr. Ray comes on. My lord, we were
Mr.
to-
Gupta, please give a little
Brief recap.
little
I understand.
recap. Very little.
My lord, these two appeals concern two charges for which the institute held
Yes.
the accused persons guilty of certain charges which were framed against them. Now, there were 10 charges in total framed against, my lord, these two chartered accountants,
Two were affected.
which two were held guilty, which are the subject matter of these appeals.
What were the charges? Just
But I'll take your lordships to that. The other two charges where they were found guilty are not the subject matter of these appeals because in respect of those charges, according to the act and the regulations, penalty or punishment cannot be provided for. It has to be referred to court. So there is a reference in respect of two other matters which we are trying to get. We are unable to
Not yet.
as of now. But that is not the subject matter.
for the present, these.
For the present, only charges 1 and 4.
Right.
Which are the subject matter where it was found guilty. My lord, on the last
Two are for
occasion,
the chartered accountant.
for the Institute of Chartered Accountants, yes. But on the last occasion, in fact, initially, my lord, when the appeal was moved, Mr. Abhrujit Mitra, my lord, had made submissions with regard to the charges and the merits of the charges. And Mr. Abrotosh Majumdar, my lord, submitted on the issue of malafide. My lord, my senior, Mr. Anirban Ray, had, my lord, dealt with the issue of malafide that on the last occasion. My lord, I have nothing to add on that. My lord, now we have to deal with the merits of the charges. Now, if your lordship kindly takes a look at page 491, I shall first take your lordship to what are the charges.
Yes.
My lord, this is, my lord, the report of the disciplinary committee. The CFI.
Right.
This is, my lord, the report of the disciplinary committee.
Yes.
My lord, we'll kindly have a look at page 491. Now, this
Yes.
is charge number 1. May I place it, my lord, in detail because this is the one charge which really has the ramifications for charge number 4 also. So, my lord, may I just in detail, my lord, please. The respondent number 1 and the respondent number 2 are partners of a firm, chartered accountants, namely Lodha and Company. This firm was initially a proprietary concern of J.S. Lodha, Kolkata, which was converted into a partnership when the respondent's father, late such and such, became a partner of J.S. Lodha in or about 1964. The respondents, along with their father, for all practical purposes at all material times, were and are the persons principally in charge and control of the conduct of the business and affairs of the said firm. From time to time, the constitution of Calcutta firm was purportedly changed and or altered. The respondent number 1 and respondent number 2 became partners of the Calcutta firm in 1988 and 86 respectively. In the Calcutta firm, the respondent number 1 and the respondent number 2 and their father, apart from some other 11 persons. This is where the issue is.
One is Harsh and 2 is Aditya.
Yes, yes. Apart from some 11 other persons were shown to be partners. The Calcutta firm apparently has 5 branches at New Delhi, Mumbai, Chennai, Bangalore, and Jaipur. That from the partnership deed dated 1st April 2002, the annual accounts for the year ending 31st March 2004 relating to assessment year 2004-5, the computation of income for the said assessment year and the statement of the partners' capital accounts and the other schedules, as also the statement under section 44 AB of the Income Tax Act 1961, all relating to Calcutta firm, it is clear that there were and are in actual point of fact only 3 partners of the Calcutta firm. being respondent number 1 and the respondent number 2 and their father. The said document is also evidence of the fact that although on record, including the data and or information given to the institute, the Calcutta firm is purported to be a partnership between 14 persons. In actual point of fact, it was a partnership of only 3 persons. That is the respondent number 1 and the respondent number 2 and their father, and all other persons reported to be shown as partners were not partners within the meaning of the Partnership Act 1932, but merely related to the firm in some other capacity. The documents mentioned as above were all signed by the respondents. Signatures of the statement of particulars under section 44AB of the Income Tax Act appeared to be on behalf of Messrs. Such and such Chartered Accountants of Calcutta, who carried out the tax audit relating to the Calcutta firm. The copy of the partnership deed would show that the same is only signed by the respondent number 1 and the respondent number 2 and their father. In the computation of income, profit and loss account as well as balance sheet, the partners named are only 3 in number, being the respondent number 1, respondent number 2 and their father. In the statement of particulars furnished under section 44AB of the Income Tax Act, the name of the partners and their profit sharing ratio as indicated refers only to the respondent number 1 and the respondent number 2 and their father. These facts show that constitution of the Calcutta firm as being a partnership of 14 persons was a hoax and a piece of humbug. From the tax audit report, it would also be evident that the tax auditors were not even informed that the Calcutta firm consisted of 14 partners. Similarly, particulars of partners' capital account refer only to the respondent number 1 and the respondent number 2 and their father and their deceased grandfather and nobody else. 4 other firms having name Lodha and Company are supposedly located in Mumbai, New Delhi, Chennai and Jaipur. But I'm not troubling your lordship with details of all these 4 places, because issue is identical, named few, and whereas the deeds show only 3. The number of persons were more and the deeds show only 3. So, my lord, kindly now comes to, my lord, page 496, 1.5.
No, the document produced before you, their statement that said that there are three partners.
No, document produced before
Those
said
showed
14.
more.
Yes.
So actually there were 3. They showed more.
They showed more. Now kindly seize page 496, 1.5.
Charges formulated.
The aforesaid charges, if proved, would render the respondents guilty of professional misconduct within the meaning of clause 1 of part 3 of the first schedule, read with section 22 of the Chartered Accountants Act 1949. Now your lordship would kindly have a look at the act once. I shall show these one. But my senior has come, so I'll just place this in. My lord, we'll kindly have a look at schedule 1 first, my lord, of part 1. I'm sorry, my lord, part 3.
Schedule 1.
Yes, schedule 1, part 3. My lord,
Part-
it is item 1.
Part 3.
Part 3, my lord. Part 3 of schedule.
Yes.
My lord,
Item
it starts with professional misconduct in relation to members of the institute generally. A member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he, then 1, includes in any statement, return or form to be submitted to the council any particulars knowing them to be false. So, my lord, this is a case where it has to be submitted to the council. Now, kindly seize 22, section 22, because the charge includes section 22 as well. This, in my humble understanding, my lord, is a much wider
More
provision.
general, yes.
Yes. Professional misconduct defined. For the purposes of this act, the expression professional misconduct shall be deemed to include any act or omission specified in any of the schedules, but nothing in this section shall construe or limit or abridge in any way the power conferred or duty cast on the council under subsection 1 of section 21 to inquire into the conduct of any member of the institute under any other circumstances. But we shall show that before the income tax authorities, whatever they submitted was something completely different. What they submitted before the institute was different. Showing this submission, they have gathered more number of works, and before the income tax authorities, they received a notice, then they submitted the penalty, and they admitted the guilt before the income tax authorities also. So this would be an act not becoming of a chartered accountant, which we found guilty of under section 22. But if your lordship, I'm sorry, but may I continue?
Yes. What?
May I go? He was sitting there, but may I continue? Well, one other charge, is charge 4. Kindly see page 497.
Yes. 497. You can start from there.
Charge 4.
Charge 4.
1 or 4. It depends.
A bit of a different approach from my side, if it's possible. May I deal with charge 1 completely, fully, because this was only the charge 1. Then
Absolutely.
your lordship will find that how charge 1 has been dealt with by the disciplinary committee, and that is, I think, that would be better, No. So, now, will kindly come.
Page 524 is charge 1.
Yes, 524. Just give me a moment. Charge 1. The first charge relates to furnishing of false information to the institute and other impelling authorities. And this is where section 22 is coming in. In respect of number of partners of the firms, in the name of Lodha and Company, by filing wrong particulars in form number 18. Respondents disclose certain number of partners to ICA, CJ, CAG and RBI, and some other number of partners to the income tax authorities. This misconduct falls under clause 1 of part 3 of the first schedule to the Chartered Accountants, which states a member of the institute, whether in practice or not, deemed to be, it's basically quotes that one. Then 29, the complainants furnished that as per documents placed on record by them, during the relevant period, there were only 3 partners in Lodha and Company, whereas in the list of firms published by the institute, names of 14 partners are shown. They stated that as per partnership deed of 1st April 2002, the firm had only 3 partners in the said firm, namely such and such. The said deed further provides the business in the name and style of such and such at Kolkata shall be carried out by the said 3 partners. Salary shall be paid to the said 3 partners, and the entire profit or loss, 100% shall be shared among the 3 partners in the ratios mentioned. The said deed has been signed by only the 3 partners only. It was further stated that as per balance sheet of such and such as 31st March 2004, entire capital has been contributed by 3 partners. The tax audit reports and competition income also show that there were only 3 partners. When I'm taking to your lordship to para 13. Complainant states as per the list of firms published by the Institute of Chartered Accountants, such and such had 14 partners, and the 14 names are given. Then 31, the complainant further stated as per the partnership deed, each of the 3 partners were entitled to a salary of such and such, which aggregates to rupees such and such. Salary to partner at such and such also tallied with the profit and loss account mentioned in the tax audit report and the competition income. So, the competition showed 3.
Mr. Rai, the list was published by you on the basis of their declaration.
Form number 18. I have to. That I have to, because that is linked to all the PSUs.
Whatever it is.
Yes, I have to.
Formality.
Then kindly sees 32. Complainants emphasize that remaining 11 partners of the such and such were neither parties to the partnership deed, nor they shared any profits. Kindly notes, not parties to, nor they shared any profits, or even the fixed remuneration share as a partner of the firm. All other documents referred by above corroborated with the partnership of the 1st April 2002, which fully proved that this partnership was duly acted upon.
What is the meaning of neither parties to the partnership firm deed? They did not sign.
They did not sign. I mean, that's English, whatever way they have.
No, whatever. We don't have any quarrel with the English, but what is the meaning? that they did not sign.
That's what that is what I
Apparently.
can also input to this one, because I am not the author also. But I think it goes like this. Neither were parties, but it should be were, neither were parties to the partnership deed, nor they shared any profit. I think they missed out the were,
Where is previous to neither? 11 partners were neither parties nor shared profits.
And I think that, so they were
Not
not
signatories because they were named in the partnership.
yes,
Otherwise,
not signatories, and not they shared any profit. I think that's what they meant.
parties to the deed means probably they did not sign. We'll go.
Yes, because just before that they said that they have not signed. So I think that is what they meant.
Yes.
Then 33 states that in case of such and such, as per list of firms published by the institute, firm has 8%. This is Mumbai, not very necessary. Then your lordship will kindly see Delhi is given at 34 and Chennai at 35. Now kindly see 36.
Chennai, Delhi also similar.
There the partners were 5. In Delhi there were 5 partners also.
Actually 5.
Kindly sees no that the contention was the same, 3 and 5. Kindly see, may I just read it out, since your lordship is 34. Complainant stated that in case of such and such Delhi, as per list published by the institute on 1st April 2001 and 2003, there are 5 partners considering of such and such, whereas balance sheets of such and such showed that they were shared by the 4 partners.
There can be sleeping partners also, but they have to share profit.
Share profits. I think subsequently I will show you, lordship, that could have been a point, but I don't think that is the basis on which this finding was made, that they are guilty.
Chennai, Delhi were not basis.
No, not really, I thought that it is something else, but it's a bit, I would say, it takes into account a lot of things together, may I just point it out, kindly comes to 36.
Yes.
In order to prove their contention, complainants quoted reference to section such and such for the meaning of words partnership, partner firm, and firm names. They further said, since the Chartered Accountants Act of such and such does not prescribe the definition of these terminologies, as per Supreme Court decision, the definition of these terminologies would be governed only by the Partnership Act for the purpose of Chartered Accountants Act. In income tax, the meaning of aforesaid terminology has also been adapted as per Partnership Act. Complainants further state that as per clause number 6 of the bank accounts of the firms can be operated by each of the 3 partners individually and none else. Thus, neither the banks were informed about the other 11 purported partners, nor such purported partners were authorized to operate the bank accounts. And the complainants also said, now
there may be 11 partners and 3 operate.
3 operates. So that's the bank accounts. Now 39. As regards some of the respondent states, that the allegations by the complainant before the institute have been repeated in proceedings under section 390 and 398. CP number such was dismissed, and with the observation that the same was procedural and was malafide. Respondent further states that documents relied upon by the complainant in support of the acts of misconduct are all inadmissible evidence. Apart from the fact that these documents have been illegally procured, these are not even certified copies, which would have been admissible under section 76 of the Indian Evidence Act. But with Mr. Mitro's submission, I think they are not anymore relying on this part, because they only themselves came and said that we have subsequently corrected the income tax records. So obviously they accept that the records were such, and that's why they went and changed it. Then kindly sees the complainants have confirmed their illegal procurement of such documents by refusing to disclose. This I had already dealt with on the last occasion. And then kindly comes 40. Respondents sought to know the manner by which the complainants had obtained the document. PAN records. This again goes back to that. Then 41. The committee asked the complainants to clarify the authenticity. It was done. Then there are certain judgments, not very important. 43 says they were not required to disclose the source. Kindly says 45 now. The respondent submitted the fact that all the partners had executed and filed form number 18, stating and confirming therein that they were partners is conclusive evidence with respect to their relationship as partners. The respondents further state that they have clearly mentioned in point number 3D of form number 18 submitted with ICAI. From time to time, it is required to state whether all the partners sharing profits of the same. Answer is no. Therefore, it was clearly disclosed that all the partners of Sunset did not have the share in the profits. Further stated by the respondent that above query number 3D was inserted by notification of 91, which goes to show that the institute consciously recognized the concept of non-profit sharing partners in a firm of chartered accountants. Therefore, no incorrect disclosures. Then, the respondents further say that the date when the partnership was entered into has been disclosed by the DC, duly signed by all the 14 partners. The proceeding respondent have shown the original copy of partnership to the disciplinary committee only and refused to file the same or a copy thereof looking into the intention and motive behind the complaint filed by the complainant. They also stated that these documents might be misused by the complainants. So the complaint was filed with the ulterior motive.
Where is the partnership deed? Which page?
Well, which one? If your lordship, they have not, what they did, they came and sought to produce the partnership deed.
Page 353, they produced the partnership deed before the committee.
But they said that we are not going to
Disclose.
put it on record or disclose it. Because under regulation 12.8, it is required that both parties will exchange. I will point out that 12.8, that was the reason.
So deed never came to the.
No, my lord. As I last time I said that if they wanted to, they could have filed it before your lordship also.
They have.
But it's too late in the day, I believe, my lord. Then, my lord, they gave certain judgments. I'm not going through that, my lord. Then, my lord, kindly comes to straight away, my lord, para 40. Well, may I just read from 48.1, because this is certain contentions of the respondent, so I must just point that out, madam. Therefore, in view of the above, the respondent submitted that it may be agreed between the partners that some of them would receive a fixed sum periodically in lieu of his shares in the profit of a firm. As regard court cases referred to by the complainant with respect to the legality of documents produced on record by them, it states that the said judgments dealt with the evidence produced by state investigation agencies. This should be kept on a different footing from illegally procured evidence. As regards the report of DC cited by the complainants, the respondents stated the complainants have cited the report of different committee without stating how they are relevant for the facts of cases cited were different as the cases were not relevant. Now 49. Respondents further state that the judgments have been referred to by the complainants for the proposition there must be an agreement of partnership in order that a partnership be constituted. In this context, the complainant has proceeded on the basis that there were no partnership agreement among all the partners, which is completely incorrect according to the submission of the respondents. And partnership agreement signed by all the parties were referred in form number 18. But why I'm referring to these, I must just show, I'm saying this, because I just wanted to show that the institute or the revision recorded whatever contentions were there.
Mr. That form 18 is a part of this.
Yes, madam.
Can you give us the page?
Yes, madam, definitely. 735A.
Yes, form 18. Thank you.
One main one would be 735B, madam, but that's a covering, madam.
Yes. Thank you.
Now, kindly, if your lordship kindly allows me, let me go to the findings, But because my intention was to show this is to everything has been recorded and considered. Now, kindly comes to 54.
Yes.
It's mentioned also as findings. The committee carefully considered all the documents, submissions, case law cited by the complainants and the records of the institute. After due consideration of the materials, committee submits its finding as under. The photocopies of the documents filed by the complainants, that is, these are the documents, clearly show that there were only 3 partners in such and such.
The complainants filed photocopies of the deed?
Yes.
So that should have been a part of the record. It's there, Annexure.
It's in affidavit in opposition of the institute, starts from page, page number bolo. Yeah, 106 থেকে তো, 106 মানে কি হয়েছে? সেটাই, হ্যাঁ হ্যাঁ, মানে the partnership deed is up to the 3 partners মানে, not the 14.
That is what we want to look at.
106 মানে.
This deed was contemporaneous with the formality. I mean, at that juncture, this was what was prevailing.
Yes, মানে. But they say that there is another partnership deed which they brought and showed to the DC.
This was the deed produced by the
By the complainant. And Malad, the other documents are also just after that, Malad.
Yes, we need not go into that. Just we
No, Malad, I just wanted to, yes.
took note of the page number. Yes.
Then, Malad, just after that, however, as per form number 18 furnished by the respondent and constitution certificate issued by ICA along with other records, the number of partners in Lodha, in the said firm was, Malad, now kindly notes, 14, 8 and 5 respectively. On a perusal on form number 18, stroke constitution certificate of such and such, impanel form or whatever it is, Malad, the committee has observed as under. In the case of the Calcutta, Malad, your lordship will find only 3 partners with the percentage of share or profit, and others are the named persons in form number 18. Similarly, Malad, your lordship will find with Delhi and Chennai, Malad, and Mumbai.
Right.
Then, Malad, 54.3 at 542, Malad, last paragraph it starts. From the above, in case of such and such, it's clear that income tax return along with balance sheet as on 31st March.
They were indicted on Kolkata or all.
All, Malad. Because the form number 18 was common, Malad. But I'll just take instructions on that, but I might be
Let us
wrong.
continue.
I might be wrong. No, let me complete, Malad. I might be wrong in that. I will inform your lordship.
Very
Sorry, Malad. I should have noticed that.
not nice.
From the above, in case of such and such, it's clear that income tax returns along with balance sheet as on 31st March filed with income tax department show only 3 partners. No other person will be shown as partners of such and such Kolkata. Further, these statements nowhere indicate or carries the name of other persons as the partners of said firm. It's important to note that financial statement and income tax return reflect the financial position of a company or firm, and they expect to reflect the names of all partners and the manner in which they are sharing the profits or losses of the firm. In addition to the computation of income tax or such and such, salary to working partners has also not been shown. Similarly, with respect to other firms registered at Mumbai and New Delhi are concerned, there is a variance in the number of partners shown in form number 18 and the constitution certificate, and the number of partners shown in the financial statement. Then, Malad, 54.4. Further, the committee noted that as per section 184(1) of Income Tax Act, a firm shall be assessed as a firm for the purpose of the Income Tax Act if the partnership is evidenced by an instrument, and 2, the individual shares of the partners are specified in that instrument. Further, as per explanation to section 184, the copy of the instrument of partnership shall be certified in writing by all the partners. Though the respondent submitted that form 18 filed by them with institute itself a certificate of partnership. However, on perusal of form 18 filed by the respondent, the institute show that form 18 on one hand shows 14 partners, whereas balance sheets of 31st March 2001 filed by them, they have shown only 3 partners.
And in form 18, they have stated that yes, there is a deed.
Yes.
They have said yes.
Yes, Malad, that is what I was just submitting on the other day. Again, I say, Malad, the institute is absolutely independent. But something has to be also considered. Malad, what could be?
No, your integrity would be at stake.
Obviously, Malad, because this will not have a reflection only on this matter, Malad, it will have other matters. Now, one thing is very important, Malad, that what could be so confidential in a partnership deed that cannot be brought on record where the earlier partnership deeds are on record. This is something very integral.
It's a registered partnership firm, must be.
Yes, has to
be registered.
Has to be.
Yes.
Then, Malad.
No, although Mr. Mitra took a point that for registration, deed is not required, which is true. But
Malad, when they say that there is a partnership deed, That is what I am
Why
on.
shouldn't adverse inference be drawn?
Yes, my lord. And my lord, may I just say this also with humility? I am saying this. My lord, even if there is a partnership deed, my lord, the act would be covered under section 22. And I will show that also, my lord. Your lordship will find what I am saying today, my lord, has now been incorporated in the schedules as an act itself after amendment of the act. I know that the amendment will not apply, but section 21 will encompass the entire thing. This will show the intention that what was required to be covered. Now, my lord, 54.6. The committee is not able to appreciate the argument of the respondents' counsel to ignore these documents only on the ground that the complainants have not disclosed the source of their procurement or that these are misappropriated or illegally procured documents. Committee is of view that since it's a matter of dispute over the number of partners in the firm on the basis of the details filed with the respondent form number 18 on balance sheets and the income tax papers submitted and the photocopy submitted by the complainant and also as agreed by all the partners in writing that they were the partners and also the empanelment form signed by all the partners as and when it was mandatory will bring to the conclusion there was a wrong particular filed either with the institute or with the income tax department. Now that is what falls under section 22, that you have given a false information either to me or to the income tax department. And I will show that this is also what the income tax department did at the very end. Malat, subject to correction from Mr. Mitro Malat, he's also my chamber senior Malat, subject to correction Malat, but he said that they approached for a correction. But I will try and establish that that may not have been the case. And that too, Malat, kindly consider this in 2011 after the findings have been already published. Now, Malat, it is not, sorry. None of the arguments of the respondent, like impaneling authorities, CAG and have not raised an issue about their partnership. Argument of the respondent does not appear to be convincing. It is neither possible nor justified to place reliance on the documents shown to the disciplinary committee by the respondents in the course of the proceedings. None of such documents or any copy thereof were filed either with the council or the committee. Neither any opportunity was given to the complainants to offer their arguments on such documents. The respondents' content is not essential to share the profits of a percentage based on a fixed remuneration can be paid to the partner. They have cited certain case laws. The committee carefully noted the facts of the present case and the difference from the cases cited. In the case cited, it is clear that there was an agreement between the parties and the fixed remuneration was in lieu of profits. In the present case, the agreement is between three parties. Well, obviously, but the other deed has not come. And the remuneration paid to others were not in lieu of profits or out of profits. Rather, it was a charge to profit, which is clear from the documents and the tax records of the firm as alleged.
They have challenged the source of production of these documents.
Yes.
The partnership deed photocopy.
Yes, madam.
But they have not challenged the
veracity of the document.
contents themselves.
Subject to correction again, but I couldn't find
We
it.
don't find it.
I did not find it, Mandal, also. Malad, that is why I found that most of the Malad, I think Malad, it depends also on the period when this was happening, Malad. I think my learned friend's client concentrated more on the Malad, the dispute, the other dispute, rather than really dealing with this.
Yeah, not you. From the shadows they were kept in busy.
Yes, Malad. Malad, I am a late entrant. Malad, as a matter of fact, when this fructified, Malad, this matter, I was not in India, Malad. So
Not in India.
Not in India. So I got my chance very late in the day.
In the piece of pie.
Yes, Malad. I'm very candid about all these things, Malad. And I have a strange feeling this will go on for the next generation also, Malad.
Now
The way things are moving.
we also have a little finger in each of your pies.
Malad.
Because all are being assigned.
And if your lordship did not have Malad, then we would have been in trouble, Malad. I know, Malad, now all matters are being assigned to your lordship.
So
And Malad was a single bench also, Malad. I think all matters are now.
trouble has been shifted from you to us.
But there we are, Malad, we really look after our own.
Absolutely. Why shouldn't?
No, Malad, that just this is in jest, Malad.
No, we are also your own.
Obviously, Malad. Obviously, Malad. Malad, this thing only remains here, Malad. After that, Malad,
Yes.
nothing remains.
Absolutely.
Malad, now 54.9.
9. We don't know. We have read. Whether you read, we forgot.
Malad, I also read, Malad.
So very well.
54.10, Malad.
Right.
The particulars furnished in Form 18 are the subject matter of dispute. However, the respondents have contended that such form duly signed by the 14 partners is an instrument evidencing the partnership. The said condition might have some force had there been no document contrary to the particulars of the form. There is a partnership deed duly supported by a number of documents which are contrary to the particulars furnished in Form 18. Conduct of the parties in the income tax returns and their other records were contrary to the particulars furnished by the respondent. And others in Form number 18 and the empanelment forms. It is not open at this stage for the respondent to say that the information furnished in Form 18 was correct and the balance sheet and other documents filed with the income tax departments were not correct or were not relevant. Without retracting from the opposite finding, committee wishes to point that the respondent have either filed false particulars to institute and empanel authorities or furnished false particulars to the tax authorities to claim salary of partners as expense and to save tax. This is an act unbecoming of a chartered accountant. But this is where section 22 is clearly included. Then 54.12. The respondents could not produce any partnership in support of the contention Form 18 under serial number 3C1, 3C, that is whether the partnership is supported by a deed, to which the answer was yes.
We saw that.
Yes. In view of the opposite committees of the considered opinion, the respondents are responsible for filing false particulars. And then 1 and 2 the same as above. And this is an act which is unbecoming of a chartered accountant. Accordingly, the committee's opinion, the respondent is guilty of professional misconduct falling within the meaning of 1 of part 3, read with section 21 and 22 of the Chartered Accountant Act. So this is where the disciplinary committee.
21 is added. It was not there in charge. But
21 was there, 22 was also there.
22 was there.
But 21 would be, it is because
formulation.
that is schedule.
Enabling basically.
That is the schedule.
No, page.
I will just.
496 is the formulation.
Yes, just gives you a moment, but I might be wrong,
21 was not there. 496 para 1.5. But 21 is probably enabling.
21 which brings in the schedule, and I'll just try.
Right. 21 does not, per se does not have. No, 21 has.
First schedule. I'll just point out.
It's a procedure.
It's a procedure,
Yes. So 21.
21.4, if your lordship kindly sees, it incorporates the first schedule.
Yes.
So since it mentioned first schedule, it just showed that it was under
Schedule was mentioned in the formulation of charges.
That is why it's 21 and 20.
Make it more proper.
Yes,
Yes. Yes.
Now, may I just take your lordship?
Charge 4 or
no, I would prefer to take your lordship to the council report.
All right.
But before that, may I just show your lordship a document which
till now we are reading the disciplinary committee report.
Yes,
right.
This was not, it was a bit haphazardly placed before. I was trying to take your lordship one after another. Now, it kindly comes to. Now, I want the order of income tax department. And just gives you a moment. Yes. Huh?
Page number 667.
Page number 667.
Yes. This is IT assessment.
Yes,
ECU 5, volume 2.
667 too?
Yes.
Yes. Kindly sees now.
Yes.
Income tax department, it is with regard to this firm, you will find in that box. And the date of the order is 10th March 2011. When did the council?
Yes.
Check that. May I just read a bit of it, only the return of income for assessment year 4 and 5 were filed by the firm on 1st November showing a total income of such and such. The return was processed under section 143(1) of the Act on 14th February 2006. Same was rectified under section 154 of the Act. Later, it came to notice that partner salary amounting to rupees 63 lakhs. No, final
Lakhs.
Only was considered for the purpose of calculating the limit under section 40B of the Act. It was discovered that payments were made to certain partners were not considered for the purpose of allowability of the partner's salary under section 40B of the Act, and accordingly there were reasons to believe that income has
This was a
escaped-
subsequent alteration. They
Yes. Has escaped assessment through wrong computation under section 40B by excluding the remunerations of working partners by subsequently taking into consideration later assessment years. Then Malad kindly says, accordingly, approval for reopening of the said assessment under 147 was sought from the additional CIT. By his letter of such and such gave the necessary approval. Thereupon notice under section 148. So it is not from their own volition. In response, the assessee by a letter of 15th of February 2011 asked for a certified copy of the reasonings, and then it went on. Then, my dear Lordship will find just after 1, 2, and 3, where they have given a partnership deed of 2004 submitted. Now, in response to the above, the such partner and authorized representative of the SC appeared on behalf of the SC and produced a copy of partnership of 18th February 2003, which replaced the previous partnership dated 31st of December 2000, which was also produced. Partnership perused and examined further as requested. The documents including the copy of certificate issued by ICA confirming the constitution of the firm as on 1st of January 2004, as well as cash book register. Other dates were produced for examination by AR. And then it continues, Malad. And then, Malad, at page 669, if your Lordship kindly comes. As per the cash book, Malad, has the Lordship got that, Malad? First, as said books, it was seen that the total remuneration paid to the individuals stated to be partners as per the constitution certificate and debited to the books of accounts were ascertained to be such and such. However, as per the computation, Malad, just go to the last sentence, Malad. The AR was also asked to submit the names, current address, and PANs of all individuals shown as partners in the constitution certificate IC. Now, Malad, that authority is looking at this authority is looking at that. So that is, Malad, what was unbecoming of a chartered accountant, and is held by that.
so it's sort of circular logic sort of thing.
Yes, Malad, because
Rely on this and get that order and say that that order is there now, so it has been validated.
yes. But one thing stands clarified, Malad. Malad, though Mr. Mitra has said it was wrong, Malad, I think, Malad, it was knowingly wrong, Malad. This is something which couldn't have escaped, and or else, Malad, also, then the computation, which is a self-computation in income tax, Malad, wouldn't have been so. Yeah.
Either it was a professional misconduct or they were bad chartered accountants who did not know their own subject, which would also affect
It's
their-
better that this is
is better than that.
Here.
This is probably better than that.
Then, Malad, will kindly come to page 82. জানি সামান্য আসলটাই হারিয়ে গেছে।
Page 82, only 82.
82, Malad. This would be, your Lordship, and the council's report.
Oh, yes.
Annexure. Thank you. This is the foundation. And this is where the council's decision comes in, Malad.
Yes.
Malad, much had been told that at night this was continuing, it was not continuing. Malad, that I thought that I have already made that submission, that obviously if we were trying to finish it, and everyone is given that clear opportunity, Malad, this cannot be a case, because I only showed, Malad, even the written notes we were supposed to file in 15 days, they filed after 1 year.
After?
Nearly 1 year, Malad, I showed, Malad, because they were taking that point on the last occasion, they took the point.
But that was considered.
That was considered. Malad, kindly sees page 84 is all the charges, Malad. Again, enumerated, enumerated,
Yes.
sorry. Enumerated. Then we'll come down, Malad, those two. Malad, kindly sees paragraph 2 onwards, but the procedural commitments of the council, my lord. I'm just trying to show that has been fulfilled. My lord, 2, 3,
Rejoinder and all.
4, my lord, hearings. And my lord, what was found by the disciplinary committee, that has been enumerated. Then, my lord, disciplinary committee, how they have come to findings, my lord, at para 5, charge 1
Yes.
has been set out, my lord. Oh, sorry, my lord, I just. And for all the charges when it's given, my lord, I'll just take your lordship now to page 117. Para 6, my lord. Your lordship asked me whether that was considered. My lord will find that the written representation was considered.
Yes.
And also made oral submissions. Council consider, paragraph 8. Council consider the report of the disciplinary committee along with the written representations and certain documents submitted by the authorized representative of the company at the same time of considering the report of the disciplinary committee. Also the oral submissions. Also consider representations. Now charge 1. Submitted the written representation report of the DC, which was inter alia as under. Income Tax Department had passed an order of 10th March 2011 where it had reassessed tax for the assessment year 2004 and 5. Assessment was done by the department after several hearings were held in the matter. By this order, the Income Tax Department has added back the amount of salaries paid to the salaried partners. So now this is an admission. This is an admission on their part, my lord. A set off against expenditure not taken into account while calculating the allowability of the remuneration payable to the partners under Section 40B of the Income Tax Act. IT Department, after examination of various documents, including the partnership deed, it refers to, kindly sees December 31st, 2001, which refers to all the 14 partners, and subsequently partnership deed of 18 December 2003, by which the number of partners increased to 17. The role played by the partners, nature of relationship among them had explained all the persons named in the said deed as partners as proceeded on that basis. So, my lord, they produced that partnership deed before the IT department, but will not produce before me. Though, my lord, under the regulations, I'll just show that, my lord, they were supposed to, they have to exchange whatever the complainants have to give. They not just like, well, Mr. Mitra, I also say it's not adversarial at this stage. But there, my lord, I will have to give opportunities both the parties. And that has been incorporated in the rules and the regulations. But there they file it. And then they say, yes, I filed the wrong return now. And the Income Tax Department has now changed it and found that the 14 partners will be considered. Sorry. Accordingly, in terms of the reassessment order, there remained, kind notes, there remained no deficiency furnished in the form number 18.
There was.
They have not said that this has been wrongly recorded, my lord, but that is what they have said. This is what it's found that they have said. And on that basis, all the income tax assessment for the relevant period has been done. Respondent further submitted, there was no dispute among the partners that certain partners have been compensated on percentage, while others are non-percentage sharing of profits. None of the partners of such have raised any issue on the matter. Relationship between the partners were decided by the common understanding and agreement.
What was the date of the disciplinary committee report? The order?
Well, this is dated
Prior to 10th March 2011, when this was done, obviously.
This one? No.
Prior to 10th March 2011, when the reassessment.
The DC report was prior.
DC report was prior.
Yes. DC report did.
After the DC report.
3rd February 2010, communicated 4th February 2011. 4th March 2011.
And 10th March this.
This 10th March. But Manad, I think the notice was issued prior to that. It's the IT department who issued the notice. So I cannot say that they.
That was the point taken before the disciplinary committee also. That does not mitigate the if at all.
Yes, it does not. Rather, it was DC did not have it. Now, my lord, 8.1.2 at page 119. Such and such has been applying for empanelment of bank audits year after year to the institute. As per the requirements, empanelment copies of income tax returns along with the copies of final accounts and returns of all the partners were attached as a part of application. Not only the income tax returns of the firm, but income returns of each partners also along with competition were also annexed with such form. Copies of returns of the firm of its partners as disclosed by the company and therefore were always in prior possession of the institute for a very considerable period. This was thus no false information furnished by the respondent with the institute.
No,
Is
if
what they
are
say.
to be empaneled for
Yes,
the
yes.
audit of certain banks, they have to take your permission, or you have to empanel them. You distribute it among the.
No. They will not take our permission. They will take our the records from us as it certified that yes, what is being said is correct.
No, has been applying for empanelment of bank accounts.
Not bank accounts, bank audits.
I'm sorry, bank audit. Mrs. Lula has been applying
To
for
the banks.
No, but it says for applying for empanelment of bank audits to the institute. So that is what we are asking.
No,
They have been applying to the institute for empanelment.
just inquire.
The modality, please inquire from your if somebody is.
I will just
Ask your juniors to take
they will
instruction.
take
on that.
instructions.
Why do what is the modality?
Yes.
Why do you apply to the institute?
Because if it has to be, if they
Either
have to ask
for permission, either for permission, or it's the institute which empanels them. Because that is one of your grounds also. That is
profited. One of them charge 4, that is the ground.
Yes.
Charge fund is the ground, madam. Yes, correct. Not only, may I just continue?
Absolutely.
Not only the income tax returns of the firm, but income tax returns of each partner also along with competition. I read this, sorry. 8.1.3. Similarly, such and such has also been applying for empanelment before the CAG for allotment of audits of PSUs year after year. As per regulatory requirements of empanelment, such as is required to file year after year the final accounts, income tax returns, competition income along with income tax returns of the full-time partners. CNAG and RBI have, upon scrutiny of such documents, satisfaction of queries, have granted constitution certificate or empaneled the firm to act as bank auditors and allotted audit of PSUs to such and such. Response quoting the following court cases. Now, Malad, in 8.1.4, again the same point of authenticity of the documents have been taken and recorded by the taken by the respondent.
They take the point of authenticity of the documents produced by the complainants, but they never produce the documents.
They never produced. And now your lordship will kindly see, Malad. Also, the income tax authorities also record.
That is quite certain.
That is the same. No, Malad. The partnership,
that
is the partnership
before them.
They produced. And also the earlier partnership also is of 3. That is also not in dispute.
It was also produced before the committee, disciplinary committee, but copies were not permitted to be circulated. Even in arbitration confidentiality clauses, I mean, even
that is between the parties. Yes, it is there.
Between the parties, it is there, but it need not be disclosed to outsiders. But audio alternate partem is hit if you don't.
If you don't give it to the.
If you rely on it, you have to.
And Malad, it is incorporated in the rules.
But the allegation is on that. The allegation is focused on that. That you have disclosed wrongly the original number of.
So, Malad, the partnership deed comes to be very important.
Absolutely. They'll have to explain why they did not do it.
And the continuous saying that it would have been dealt with otherwise by the persons.
Well, insinuation was given by Mr. Mitra on instruction, obviously, that this should help the builders in some manner. I mean, knowing the contents of a
partnership, I don't know how it will
just produce before the income tax authorities. If you rely on that, we don't know. They will explain.
They will explain. Then, Malad, 8.1.5. Counsel further noted that the complainants did not submit anything with respect to this charge. Complainants counsel at the time of consideration of the report by the counsel further submitted that all the charges wherein the disciplinary committee has held the respondent guilty of professional or the misconduct, they are accepting the disciplinary committee report and have nothing further to mention. At the time of consideration of the report, the counsel, the response dated what has been submitted in the written submissions and further submitted. There is an agreement by the partners in a partnership firm, and out of the profits so on, some of the partners were drawing remuneration on fixed basis. And Malad, they go on continuing the same things, Malad. Section 40B, whatever I've read from the assessment, I'm not reading that. No. 8.1.6. On perusal of the documents brought on record, including DC committee report, the written representation of complaint, as well as the oral submissions and of the complaints, the respondent noted that the papers now relied upon by the respondent is a fresh piece of evidence. The respondent brought on record that the assessment of income of the assessee firm for the assessment year were reopened under Section 147 of the Income Tax Act. The assessing officer, while perusing the documents brought on record by the assessee, were of the view that all the partners were drawing remuneration percentage share in the profits and were drawing remuneration fixed basis in lieu of profits were all of the partners of the assessee firm. In this context, counsel was of the view that the fresh evidence which had been brought on record by the respondents are the assessment orders in the Assembly of 245. Limited purpose of these assessment orders only from the angle of revenue collection by the department, whereas the proceedings before the disciplinary committee. The matter before the council, the T has been wrongly made in caps. The matters before the council are separate sets of proceedings. The assessment order so passed in concern does not have any bearing on the matter which is before the council of the institute with respect to the number of partners of the firm. In this context, the council further noted the respondents have brought on record before the income tax department partnership deeds of 31st December 2001, whereas if the respondents have relied upon this so-called partnership deed, then accordingly the same should have been placed on record by them with the committee. And if not so, before the committee or at least for the council for coming to an independent opinion. The council further noted that returns which had been enclosed by the respondent about the income tax returns filed by the so-called partners are concerned. It was categorically seen that some of the so-called partners, while filing their incomes, had shown their income as salary from the firm. And in support of this, even the salary certificates were also enclosed, along with the copy of return, which further strengthens the fact that these are so-called partners who in fact drawing salary. Also observed by the council, though in form number 18 filed by the respondent under serial number 3C, whether the partnership supported by the deed, which the answer was yes. However, the respondent no point at all produced the said partnership deed which they have produced with the income tax department. Accordingly, the council accepts the report of the disciplinary committee insofar as the response for filing false particulars.
Sir, in law, the remuneration of a partner may not be in the in profit sharing ratio, but in by way of salary.
Yes,
That may be.
but the disclosures have to be made.
Yes, sir, that is different.
For the purpose of they would have to go and say, look, these are the partners, they are on remuneration basis and they are on percentage.
Nothing was.
That is allowed, but not saying anything and just showing percentage basis. And that may not be allowed.
And the mischief has already been done because they have obtained orders.
On the basis of the
empanelments and all these on the basis of this. That is your allegation.
That is also an allegation. That is charge 4.
There is a charge 4.
That is charge 4. May I now take your lordship to charge 4?
Charge 4 is actually dependent on 1 also.
1, absolutely, my lord. May I just?
Yes, 125.
না অডিটের কথা বলছে না অডিট গুলোর জন্য কি চার্টার্ড অ্যাকাউন্টেন্ট ইনস্টিটিউটের কাছে অ্যাপ্লাই ব্যাংক অ্যাপ্লাই করে না কি করে ওরা ডাইরেক্টলি ব্যাংকে অ্যাপ্লাই করে হ্যাঁ
ওরা কিছু করে না ডাইরেক্টলি ব্যাংক যে অডিট গুলো করে সেটা
ব্যাংকের অডিট গুলো করার জন্য তো লোধাকে ভাড়া করা হয় সেটা কি ডাইরেক্ট ব্যাংকে অ্যাপ্লাই করে নাকি ইনস্টিটিউটের থ্রু দিয়ে না মানে ইটস নট থ্রু দ্য ইনস্টিটিউট মানে অ্যাপ্লিকেশন
So this was probably a wrong recording.
Wrong recording or something meant otherwise, my lord. The English part is
No.
and there will be more mathematics in this English, my lord. So, and then, my lord, may I just take your lordship to the charge 4 ki pore diyechish? Well, may I just read to your lordship?
They speak more figuratively than literally.
Very grateful, my lord.
With figures. Yes.
That they do. Well, I stand in awe whenever my senior starts on scrutinizing a balance sheet, but I really don't.
Not our forte either. We rely entirely on whatever.
I don't know whether your lordship knows. He was actually trying to go that way.
That is just he caught the wind.
I'm sure the wind. I'm sure the wind was this way.
No, the attitude of the court and then yes.
And let me come back to page 497. Unacceptable.
497 is a disciplinary committee.
But I'll just place the charge 4 from
yes.
there itself.
We omitted that. Yes.
I did, my lord, because I thought that, my
Yes,
lord,
you said better to follow the logical conclusion
Yes.
of one. Yes,
charge 1 is done, my lord, charge
4.
4. And the দেখানোর থেকে আমি পৌঁছে গেছি এই তো এখানে তো পাশেই মানে কাইন্ডলি সিজ চার্জ 4 1.9 পেজ 497 ঠিক আছে The audit assignment of public sector undertakings are granted in practice to firms having regard to the size of the firm and the number of partners. In order to solicit business from and to fulfill the eligibility criteria prescribed by or on behalf of the public sector undertakings in the matter of appointment of auditors, the respondents manipulated the constitution of the said 5 firms, as more fully mentioned herein before, in order to show large number of partners and thereby acquire professional works for themselves and their father, whatever. Therefore, violation of clause 5 of part 1 and clause 1 of part 3 of the first schedule under section 21 read with section 22. But here also when section 21 has been mentioned, let me I just now take your lordship to clause 5 of part 1. এটা তো part 3. My lord, part 1 first schedule, my lord. Has your lordship, sorry, yes, ma'am.
We have seen 5.
Secures and my lord, part clause 1 of part 3 which has already been read, my lord, earlier.
So read with.
Yes. As it fell from your lordship, my lord, both are interlinked.
Has to be.
Has to be, my lord. Accordingly, your lordship will then come to how the DC
But 1.5 says, part 1.5 says,
secure
secures either through the services of a person not qualified to be his partner or by means which are not open to a chartered accountant any professional business. So he solicited, they solicited business.
which might not be open because they wouldn't have had the partnership strength.
That open part comes in.
Open comes. And then, my lord, may I just take your
It
lordship?
is not open because of 1.
Because of 1.
3.1, I mean.
My lord.
Good.
Now, my lord, may I take your lordship to charge 4?
The charge for on page 549.
549, my lord.
Yes.
58.
Finding it as is at 551.
Para
549 it starts, very well you can start.
Yeah, 558, my lord. I'm sorry, para 58.
Yes. That is a declaration before the other CAG,
Yes, my lord.
RBI and institute.
My lord, this is what has been held, my lord.
Yes.
Therefore, obtained allotment of audits of large.
Again, they say impanelment to the institute.
This charge relates to declaration of excessive number of partners to CAG, RBI Institute and other impanel authority with the object to solicit large audits. The complainant stated that such and such has maintained 2 sets of documents for partnership. One set filed with the institute on impaneled form, filed with CAG or PT committee of the institute and RBI. Therefore, Ms. Such and such obtained allotment of audits of larger PSUs and banks, including Navratans, by inducing CAG and RBI with wrong declaration of number
What
of
is Navratans?
These are PSU companies who are mentioned as Navratan companies, and there are mini Navratans also. Indian Oil Corporation is Navratan, Bhel is mini Navratan. These are new.
There are 9 Navratan. As in Akbar's court or?
But I think it is metaphorical.
Metaphoric, obviously, Akbar or Vikramaditya or the curry, which you have in hotels.
Vikramaditya. He knows better than me. I thought it was this era, Malad. There is an era, Malad, your lordship is missing out. This is also an era, Malad.
That was an era. Now we are there. We are going there gradually.
Absolutely, Malad. But I really do have my reservations. Whatever not to be talked about here.
No, don't.
But scary.
Very
scary. Now, Malad 59. The respondent stated that such and such has been applying for empanelment of audits year after year to the institute, In its application to the Institute for Empanelment of Audit for the year 2003-4, number of partners been clearly disclosed by such and such. All income tax returns of such and such along with final accounts of the firm were also annexed with such form for empanelment. Similarly, such as applying for empanelment before such and such allotment of audits of PSU year after year, CNAG as an independent regulator after scrutinizing all the records empaneled such and such an allotted audit of respective PSUs. The respondent further stated that such and such has been peer reviewed twice and received peer review certificate. This is their submission, Malad. Was carried out for the year such and such. The respondent stated that all the partners acted and discharged their duties as partners, including attending meeting of audit committees of several clients, signing audit reports of many listed and unlisted companies. Respondent stated that the firm had well over 40 to 50 qualified paid assistants at all times, and a clear distinction was always maintained between partners and qualified paid assistants. Then the response stated the complainants filed the same complaint with the CAG. They explained to CAG on the exactly same issue. CNAG went through the entire documents. Even the income tax authorities refused to share the documents to RTI. Response stated that their hands were tied because if they produced everything, it would be misused by their party.
By their party means?
I think, Malad, not by their party, by the other party. I think it should be by the other party, Malad. The respondent always disclosed in Form 18 what is their basis was, how they have filed their records, and not only that, with this respect, they took the precaution, they filed the letter to the Institute for Bank Empanelment when they filed the application to CNAG, given in the covering application, whole basis of the filing. They filed each and every return. He submitted that Form 18 which was filed with the Institute was absolutely correct. Not only signed balance sheets, they have given different undertakings to the Institute under Form 18 under the banking empanelment to CAG. The committee asked the respondent to produce evidence showing that the allegations by the said alleged matter are similar with the cases filed with the different authorities. In this regard, the respondent requested the committee member that they could produce the same, but those documents would not be parted with the complainants. Well, they say that it's the complainants who themselves.
Yes, exactly.
I really don't understand this, Malad. But as I said, Malad, I think they were more focused in Malad, Bengali terms, Malad, Gofel Lorai. So, Malad, I think.
Bengali terms?
Gofel Lorai, Malad.
No, not Gof.
No, this is very, very wealthy Gof, Malad.
Very well.
Very wealthy.
Waxed and
yes,
like Arkul Pearl.
Yes, even longer than that, I'm sure. देखिए दीजिए जज साहब দেখে নিয়েছে উনি নিজেই জিজ্ঞেস করে দেখে নিয়েছেন The respondents produced the documents including copy of parliament before the committee and same was returned back to the respondent of the perusal by the committee. Now the findings. The committee has carefully considered the submissions and other material submitted by both the parties and submit as follows. Admittedly, the respondents of the firms have filed same particulars the impaneling authority which they have filed with the institute. In view of the finding, the committees of the opinion the respondents have filed false particulars the impaneling authorities too. So far as disposal of complaints with CNAG and other authorities is concerned, the committee cannot take cognizance of the documents shown to the committee because the same or their copy was neither filed before it nor shown or confronted with the complainants. Further, the facts and present with CNAG and others are not before the committee. The committee thus is not inclined to place reliance on such papers. In view of above, in the opinion of the committee, the respondents are guilty of professional misconduct in terms of clause 1 of part 3 of the first schedule of the Chartered Accountant
Were
Act.
they discharged by the CAG and the other authorities? Did they disclose anything on that?
No, they have not disclosed. That's what the finding is.
The outcome is also not disclosed.
They're on orally, they say. That's there, man. That's recorded as a matter of fact. No, man, it does not.
But this is a not very good finding because.
Well, the finding is a bit cryptic, if I may say so. But Manad, I think they're relying more on the findings in charge 1 to come to this conclusion.
Yes, and also the previous paragraphs, they relied on the. Anyway, whatever.
The issue is, Manad, for filing different statements, they have taken advantage of empanelment for higher number of works, if I may say so. What are the one, Jolly?
And in any event, whoever seeks to empanel them would obviously be verifying with the institute as to their credentials.
But the institute was also now the
institute that verification would be that
on the basis of Form 18.
Yes, you would be disclosing whatever is there.
Whatever is there, And but that document again, my lord.
So that is the reason why charge 1 is connected with 4.
Yes, my lord. So, my lord, it has to be read together, my lord, to a certain extent for the findings, my lord. Since, my lord, why I say this, my lord, the DC committee goes on the findings as a totality.
Mr. Rai, what are the nature of the other allegations on which they were exonerated? I mean, 1 or 2 just.
My lord, there were other allegations. May I just take, my lord, let us say, take charge 5, my lord.
Yes.
The charge is that the respondents have allowed the persons other than their partners to sign statutory and tax audit reports as their partners. And are thus guilty under clause 13 of part 1 of the first schedule. And that they stated, and my lord, the finding is.
Real evidence was found. That is the finding.
Yes, my lord.
Well, so not that on principle this was
No, my lord.
negated in the other.
No. And my lord, I will also come to that, my lord, because I am a bit.
6, 9, and 10 found guilty reference.
Yes, my lord, 6, 9, and 10, that has been referred to. But there is a separate reference.
Oh, right. 6, 9, and 10
But
they have
yes,
also.
well, that is why even the prayers, my lord, to a certain extent, I would like to place before your lordship what I feel is correct. Then your lordship will decide whether your lordship will mold the
They
prayers.
challenge the entire.
Yes, that is what, my lord, they
That
couldn't.
obviously will be.
They couldn't have, my lord.
No, no question of molding. We'll hold that regarding that portion they're not entitled to.
They are not entitled because that has to be in the reference, my lord.
They have already preferred reference, and which is.
No, we have preferred reference.
Oh, you have preferred it, right?
Because, my lord, once
That has to be confirmed.
yeah, that has to be confirmed by your lordship's court. So till that time, my lord, that is not given.
Not
effect to
attained
these.
finality.
No, that has not attained finality. And this has been challenged, my lord, this is a separate provision.
Right.
So that has been done accordingly.
Those are more serious, I suppose.
My lord, yes, I believe, my lord.
Otherwise,
My lord, 6 is, my lord, this together. My lord, page 553. I'm just reading it out, just for your lordship.
yes,
These charges pertain to conducting of audits of 2 companies,
that is serious fraud, probably.
with the respondents participate in the management of the affairs of said companies, thereby affecting the independence of auditors.
Yes, because right. If
Well,
it requires confirmation by this court,
This needs confirmation.
like a death reference.
No, my lord,
bad example, but
no, whatever it is, my lord. Why I say, my lord,
we can cite the Indian Divorce Act. Previously, there used to be a confirmation by 3 judges of this bench, this
I
court.
didn't know that.
If there was a divorce passed under the Indian Divorce Act, which governed the Christians and the others, it was required to be confirmed by a 3-judge bench of this
Know
court.
that, my lord.
I had done a confirmation matter that was subsequently
It's also
amended,
there, my lord.
obviously, yes. Actually, our indigenous laws were much more progressive than
Has
the
to
laws
be.
of our rulers,
Has to be.
quote unquote.
Has to be.
Yes, anyway, let us. Yes. No, not has to be.
I will say why, my lord. Because
Not has to be.
I will say
We
why
may
I
not
say,
be more progressive than our rulers.
why I say
Many aspects.
why. Yes, my lord, that also I believe. But why I say has to be, my lord, just taking 1 minute.
Yes.
My lord, I believe law is inbuilt into the community and the society as at large. If you are not a
Provided that
part of
gets
it,
an expression in proper forums. The communities.
that's again, my lord, law is one and the forum is the other.
It has to have a platform.
It has to, but law
The
has to be designed.
public. Anyway,
I
that's a
understand.
different.
Law has to be in such a fashion it understand the pathos of the person.
We only know that in our school we were scared of our teachers' rulers,
Oh, my lord.
which used to hit on knuckles sometimes.
My lord, nowadays,
Those rulers,
Can't even
not the other rulers.
nowadays you cannot mention that.
Nowadays,
My lord, you are not choosing words. Even if I would have slapped my own son, and still we feel that was a better way of dealing with.
but they're much more aware of the world than us.
My lord, I have seen, my
Much-
lord, children saying that I will complain to
You
the
can
police.
take advice from them completely.
Yes, my lord,
Rather than your
definitely.
generation, it's better to take
Yes,
advice
yes,
from
my
the
lord. And
Gen Z and
they
Gen
are so
whatever
focused.
has followed.
They are so focused.
Much better. So let us end this generation first.
My lord,
Yes.
yes, my lord, may I come to D and C now?
BNC.
I'm sorry, my lord, the council report.
Page.
And that your lordship kindly comes back to page 8, the first volume, my lord, I'll just take it. Huh?
83.
83 না 83 তে শুরু হচ্ছে পেজ 4টা বলে দিই শুধু 80 উফ, পেজ 125 মানে কি হলো উফ। থ্যাংক ইউ
Yes, 125 is charge 4 of, but that,
This has been recorded.
yes, yes.
That's very small, my lord.
Good.
It kindly takes 8.3.2. They say it wouldn't fall under scope of clause 1 of part 3.
Hmm.
And how has it been dealt with, Malad? Well, may I just read together, Malad? Respondents emphasize that both CNG and RBI are statutory authorities, and judgment of those authorities as to whether certain information filed with them was true or untrue deserves to be respected by other similar authorities. The respondent further submitted, even if one were to assume hypothetically and for argument's sake only, the information furnished to these authorities by the respondent's firm was untrue as alleged, this act would not fall under the scope of clause 1 of part 3 of the first schedule. The council also noted that the complainants did not submit anything with respect to this charge since the disciplinary committee has held the respondent guilty of professional misconduct. Now 8.3.2. Council took into consideration submissions made to the respondent with respect to this charge, along with the report of the disciplinary committee, and further noted, since the respondent and the firms have filed different sets of papers before different authorities. Moreover, the respondents have failed to bring on record as to what papers they have filed before other authorities. The said information are within their personal knowledge, and thus the onus to prove the same rested with the respondents if they have failed to do so. Accordingly, the council has accepted the report of the disciplinary committee. And again,
Apparently, they were exonerated there because they have said that they are independent statutory authorities, and judgments of these authorities as to whether certain information filed with them was true or untrue deserves to be respected. But we don't know. That
don't
maybe
know. At the DC stage, they did not know.
no.
That was the finding of the DC. That
they may refer to the acceptance of the information in
yes,
the first place.
yes. And in the DC, at the time of DC, they did not get these documents.
No, but what, did the complainants produce any documents to show that they had misrepresented before other authorities?
Well,
we don't know. They might have represented that they have 3 partners before
no,
other authorities.
This is basically, kindly sees. This is what the respondent says.
But this is all you say about the charge.
No, that is, this is not the charge. This is the finding on the charge.
The finding. This is the entire finding.
Yes, this was has to be read in conjunction with the disciplinary committee report.
No, what did what documents did the complainants produce?
They only produced that the PSUs have been receiving PSU works because of this higher number of partners.
Achha.
To which the respondent says, sorry,
no, please
continue. To which the respondent said,
yes,
that these kinds of proceedings have already been undertaken before the CAG and RBI. And they have given, now they are saying they have given favorable findings. But those were never brought on record before the DC. So, the finding here is, that you should have brought it on record. Once we hold that on the basis of these 14 which you have given, you have received empanelments in CAG and RBI, you should have brought on record, because if you are saying that those are what are to be relied upon for the purpose of disposal of this charge, you should have brought that on record.
It should have been better. It would be better if there was more clarity in your finding on this charge 4. Because there can be 2 situations. One, before the other authorities, they said that we have 3 partners. Suppose they say that. Then they are not guilty of this charge. I mean, they're inflating the number of partners. But then also that is tied up to, because they get the job in the first place as chartered accountants, as members of your institute. So therefore, Form 18, that's tied up to Form 18 again.
That yes, they get the volume from the numbers.
Yes, the volume
will be from Form 18.
Volume
of what?
Suppose before that authority they said that we have only 3 partners. So therefore, charge 1 vis-a-vis those impaneling authorities does not per se apply, because they gave the correct information according to you, because they had 3 partners. But then also they got that job in the first place because they are your members, where Form 18 has been.
Well, they are saying that such complaints have been made before CAG, not that these documents have been accepted. They are saying
the premise of incriminating them under charge. That's what we're saying.
Only once.
We don't know that they have got a single job from this. That they have got a single assignment on false information. That is not before us.
No, what they have said is, the respondents have
complainants have to say. It's respondents come later.
Complainant has said because of the number which has been discrepant in form number 18,
That is what we say.
they are
So
there.
even if they disclose, respondents try to shift it to
The
they are
complaint.
being exonerated there.
Third parties.
So they might have disclosed the correct facts there. We don't know
we
that.
don't know.
But even if we don't know that, you cannot go by that because you are still tied up to Form 18.
Form 18.
If they misrepresented in Form 18, they get the jobs also as chartered accountants and members of your institute.
On the basis of form number 18.
Yes, that's why it is so crucial to know what role you have to play in there getting those empanelments.
But I will.
That you have any role,
The role is, Malad,
giving permission.
I'm certifying form number 18, Malad.
That is what we are asking.
When I'm certifying form number, it is known as the certifying certificate also, Malad. You will find that it has been written in all the places. So, Malad, when I'm giving that, Malad, all these authorities will trust that record.
Yes.
Now, then I say, Malad, the owner shifts.
All right.
Because if they are saying that on the same basis they have been exonerated by those authorities, they should get it on record.
Yes.
That is the reason, Malad. I don't know. I don't understand why this always, Malad, there are other parties, Malad, they are exonerated. That is also going to affect them. Malad, this is something which is not, Malad.
Intriguing.
Yes, very intriguing. They have been exonerated, they are saying. Then what is the problem?
Yes.
It's not that they're keeping it away from the persons concerned that there were other proceedings before CAG and RBI. That they are saying. But after that, they are not ready, Malad. So, Malad, this is charge 1 and charge 4. Malad, before I go to Malad, I'll rely on certain judgments, Malad. Malad, before I go there, Malad, may I just, for the completeness of the arguments, Malad, kindly comes to, Malad, the Act, Malad. Regulation of product 12(8). Section 21, Malad.
Yes.
Kindly comes to, Malad, 21(4). Where the findings is that a member of the institute has been guilty of professional misconduct specified in the first schedule. The council shall afford to the member an opportunity of being heard before orders are passed against him on the case and may thereafter make any of the following orders, namely, reprimand, remove the name of the members from the register. Now, provided that where it appears to the council that the case is one where the name of the members ought to be removed from the register for a period exceeding 5 years, it shall not make any order referred to in clause A or B, but shall forward the case to the High Court with its recommendations. So, Malad, if it's less than 5 years, Malad, obviously there is no recommendation required. Then, Malad, kindly sees where the misconduct in respect of which the council has found any member is guilty of misconduct other than any such misconduct referred to in subsection 4. So, Malad, when it is beyond the first schedule, Malad, shall forward the case to the High Court with its recommendation thereon.
No, then.
And Malad, that is the reference.
So removed from register for a period exceeding 5 years.
5 years, if it's in the first schedule, Malad, if it's in excess of 5 years, removal, High Court, or else not to the High Court.
It shall not make any order referred to in this, but shall forward the. Oh, no order will be made. Directly forwarded to High Court. And where misconduct
where it is beyond schedule 1, Malad, first schedule.
Other than any misconduct as is referred to in 4.
Which is first schedule, Malad.
First schedule, right.
Then that will be referred. Those are the other ones which have been referred.
Right. So in first schedule cases where no removal or permanent this thing, no, what punishment has been given to them?
What is the punishment? No. I'm just.
Must be less than.
Yes. I think 3 months.
3 months removal.
No. Suspension. That they would be knowing.
May not disclose the papers on that. Going by their past conduct.
But only one more section, Malad, kindly sees 22. 22A, Malad, appeals.
Yes.
any member of the institute agreed by any order of the council imposing on him any of the penalties referred to in subsection 4 of section 21 may within 30 days from the date on which the order is communicated prefer an appeal. So
Yes.
that's 4.
Yes.
Just a minute.
4 is first schedule.
Yes, that is my lord. I'm just trying to break it up, my lord.
Oh, the
So,
difference in this.
Yes,
Yes, yes.
the
Get-
4 only these 2 charges. So they
Yes.
can only challenge these 2
Right.
in this appeal before your lordship,
Right.
not the others, my lord. That is not what I wanted to.
Because that has not attained finality.
Yes,
As-
that will become a part of the reference.
And if we confirm it, then we become our own appellate authority.
And my lord, that is no longer kept before your lordship.
If this court confirms it, or other way around, then we are sitting in appeal over our own
Yes,
judgment.
my lord. So that
Obviously,
is
that cannot be.
so that I just wanted to point out, my lord. I'll my lord,
Just come back and take the
I'll just-
citations or
yes,
whatever.
my lord, please.
Yes.
Malad, only Malad kindly looks into regulation Malad 12 once and then I'll take your lordship's judgment Malad.
Regulations আমাদের দিয়েছিল কপি দিয়েছিল yes
Malad 12 talks about Malad a complaint under section 21.
right
Malad, what I want to show more is Malad kindly takes 12.7.
hmm
12.7 says the complaint should go to the member concerned. Then 12.8 Malad, on receipt of the written statement, if any, the secretary shall send a copy thereof to the complainant. So, Malad, whatever is being produced by each of the parties is to be exchanged. And at the very end, if your lordship finds, at 12.11, perusal of the complaint, written statement, rejoinder, any respondent's comments or the complaint's rejoinder, if any, and other relevant documents, counsel is of the prima facie opinion. So, Malad, where the complainant is also being given a chance of a rejoinder, Malad, so whatever they have to say in the written statement, including documents, Malad, has to be, Malad, given a chance to the complainant. Then whether, Malad, how I will deal with it is my object. And even in 12.10, your lordship will kindly find the counsel can also look into any documents.
it does not specifically provide that regarding pleadings it's provided copies to be given documents if
If
the
your lordship-
council looks into it they took advantage of that
Malad,
does not specifically say that
I will say, Malad, because, Malad,
but the
if your lordship sees
principles of audio altering partner are inbuilt in this
Malad,
hearing.
kindly sees 12.3, Malad,
3 yes
sorry, 12.1.3,
yes
where the complainant is required to put in all the documentary evidence and
12
oral law documentary relied upon in support of the allegations, Malad.
where is that
Malad, 12.1, sorry, key hoche,
1 3
12.3, Malad.
yes
Such complaints should contain. And 12.3b, oral and documentary evidence.
that is not provided for written statement
No, Malad, I am saying that it should be read into it. Because it has to be, Malad,
to
what
be,
is.
to be.
That's why I said so, Malad, that they should have, because I have to give it to the other person who has made the complaint for him to file the rejoinder. Or else, Malad, that will become a empty formality. I'm just trying to show that they said that documents I cannot disclose, but it was required to be disclosed because of
And
this.
it says in 7 that within such time, a member against whom complaint within 14 days such and such a written statement in his defense verified in the same manner as the complaint.
Complaint.
So that takes into
That
consideration
incorporates
3 also.
Malad.
2 and 3, yes. Anyway,
This
so
is what
that we have to read in. If someone,
Yes, but I see
the authority relies on a document,
regulation. I also read regulation. Now, Malad,
that is one aspect as we indicated, they have to deal with.
Malad.
Why didn't they disclose those documents? Yes. And why shouldn't adverse inference be drawn for that?
Now, Malad,
Yes.
I will make not submissions, but I will refer to judgments, Malad, with regard to 3 propositions. The first proposition is, Malad, mens rea. And Mr. Mitra has referred to us to 2 judgments, Malad, saying that mens rea needs to be fulfilled. I would like to submit a bit otherwise, Malad, that in civil obligations, Malad, mens rea is not an essential ingredient.
But there's a penal provision.
There is a penal provision, but for misconduct, Malad, mens rea will not be required. Penal provision, Malad, can be there. If it's a civil obligation, Malad, but your lordship will find, let's say, SEBI or Malad.
39(2)(a) is there. But the consideration remains 1.
Yes.
And you can send one to prison for non-compliance of a permanent injunction decree. But the considerations in that is civil,
Civil obligation.
preponderance.
And it does not also imbibe into it any mens rea also.
All right.
I will show 3 judgments for this. Next will be, my lord, what is misconduct and what is the effect of an inclusive definition of misconduct. So these are the 3 propositions. Yeah, my lord. The first judgment is 2006, 5 Supreme Court cases, 361 का देखो तो देखिए and paragraphs 29, 33 and 35. हाथ लेके जाए and there's a discussion, my lord. This is with regard to SEBI, my lord, and the penal nature of their, my lord, if for violations of, my lord,
29 is there.
yes, my lord, kindly sees from 28 onwards. In the present case, respondents on their own admission have violated the aforesaid statutory regulation during 6 quarters. Hence, Mr. Sanchez submitted that the violation is ex facie willful, and hence the penalty imposed by the adjutant officer ought not to have been set aside by the single member tribunal. Mr. Rao further argues that unless the language of the statute indicates the need to establish the elements of mens rea, it is generally sufficient to prove that a default in complying with the statute has occurred. Under section 15D and 15E, there is nothing which requires that mens rea must be proved before penalty can be imposed under these provisions. Then, my lord, 29. Hence, it was contended that once the contravention is established, the penalty has to follow. Then 29, my lord, it continues and deals with this. My lord, kindly sees placetum C on the next page.
We are reading that, yes.
In our opinion, mens rea is not.
This apart.
From B, my lord. In our opinion, mens rea is not an essential ingredient for contravention of the provisions of a civil act. In our view, the penalty is attracted as soon as contravention of the statutory obligation as contemplated by the Act is established. And therefore, the intention of the parties committing such violation becomes immaterial. In other words, the breach of a civil obligation which attracts penalty under the provisions of an Act would immediately attract the levy of penalty irrespective of the fact whether the contravention was made by the defaulter with any guilty intention or not. This, but unless the language of the statute indicates the need to establish the elements of mens rea, is generally sufficient to prove that a default in complying with the statute has occurred. Under the close scrutiny of such sense, there is nothing which requires that mens rea must be proved before penalty can be imposed.
Yes.
Hence, we are of the view that once the contravention is established, then the penalty has to follow, and only the quantum of penalty is discretionary. But then, my lord, kindly sees, my lord, the intention of the parties, my lord, just between D and E. The intention of the parties is wholly irrelevant since there has been a clear violation of statutory regulation provisions repeatedly covering a period of 6 quarters. Hence, we hold that the response have willfully violated statutory provisions with impunity. Hence, the imposition of penalty was fully justified. The tribunal in this context failed to appreciate that every mutual fund has to redeem the units as per terms and condition scheme on the request of the unit holder, and this cannot in any manner be considered extraordinary circumstances or something which was not known to the respondent. The facts and circumstances of the present case in no way indicate the existence of special circumstances so as to waive the penalty imposed by the adjudicating authority.
No, the Supreme Court says the intention of parties is wholly irrelevant, but then goes on to say that
Yes, but the finding is such, my lord.
up to that, rely up to that.
I rely up to that, my lord. Here also, but why I'm saying this, my lord, here
The
why
intention was definitely willful. It was willful.
why I referred to this, my lord. If your lordship, my lord, that part I have already. But in this case, my lord, your lordship will find that from the conduct, it would become evident that they were aware. They were aware that they are filing 2 different particulars in 2 different places.
How could they not be aware? I mean,
So that itself, my lord.
yes.
My lord, next case, my lord.
What was the violation here in the SEBI Act? Nature of violation?
My lord, violation, my lord, here was, my lord, for 6
quarters they had not filed something.
quarters they have not.
Failed to comply certificate of registration. routed transactions through associated brokerage houses and all that.
Yes,
In excess of permissible. Very. Leave it.
there are 6 your lordship will find it.
No, need not. We have found it.
Huh?
So you're relying on para 33 also.
33 months. Whether an essential element for imposing penalty for breach of civil obligation. Mainstream. But most of the judgments are referred to here, Malak.
Then don't refer to those judgments.
No, we won't. Malak.
Despite whatever coaxing and
No,
inducement you have from either side. I mean,
absolutely not, Malak. So, Malak, your lordship will find that they refer to Director of Enforcement NTM, where thus breach of a civil obligation attracts penalty under FERA, and a finding the delinquent has contravention of the provisions of Section 10, immediately attract the levy of penalty under Section 23, irrespective of the fact that the contravention was made by the defaulter with any guilty intention or not. Malad, I'm just pausing here for one moment, Malad. In this case also, Malad, that's why, Malad, I say there is a distinction between what is there in the first schedule, Malad, under 21(4), which allows immediate, Malad, punishment or penalty,
right.
And the rest.
We'll remember this while taking up those references.
Malad. Yes, Malad. I hope it is. Steps are
No, but yet you're right. So it's a civil statute. It's a civil statute, penal consequence. CA Act is, nobody can argue that's a penal statute. Unless being a CA is a penal offense. But otherwise.
But here they are also holding SEBI FERA to be civil statute.
Yes.
That's what I want.
Oh, yes, right.
SEBI and FERA are also civil statute. But I was told my father was intricated on FERA because he had a 10 rupee note in his pocket when he came down from England. So those were the days. I've heard about those days.
Yes.
Now, in our considered para 35,
Seen that. The converse.
So therefore, I'm relying on this judgment.
Yes,
Next,
yes.
I mean, ek kuch na to. এর মধ্যে কিছু দেখাচ্ছে না তো 2022 4 Supreme Court cases 516 মানে this is a breach of employees provident fund মানে para 15 and 19 মানে Malad, here I will not read earlier paragraphs because this is again a lift off from Malad, the earlier judgment. But 15.
Yes.
Taking note of the exposition of law on the subject, it is well settled that mens rea or actus reus is not an essential element for imposing penalty or damages for breach of civil obligations and liabilities. And then 19, Malad. Refers to Malad, the 3 judges bench, which we are not relying today, Malad. We have the considered view that any default or dealing payment EPF or the act is sine qua non for imposition of levy or damage under Section 14B, and mens rea or actus reus is not an essential element for. Now, Malad, the next judgment is. Para 12 plus June.
12 plus June. ঠিক আছে 17
The action. It just gives you a moment. Let me see whether Malad, this really needs to be referred because it's there in the earlier judgment, but Malad, I was only referring to one small. Malad, may I just read one paragraph from here, Malad?
From the one which you just now placed?
No, Malad, this is the one which has been referred to there, but not the paragraph which I want to
give the citation for
1979.
Yes.
2 Supreme Court cases, 286.
Any particular paragraph?
Yes, Malad, particular paragraph is 12. Malad, this concerned, Malad, misconduct. Also, Malad. more of disciplinary actions under the retirement rules. And where your lordship will kindly take, my lord, paragraph 12. The High Court was of the opinion that misconduct in the context of disciplinary proceedings means misbehavior involving some form of guilty mind of mens rea. We find it difficult to subscribe in this view because gross or habitual negligence in performance of duty may not involve mens rea but may still constitute misconduct for disciplinary action. Now,
Disciplinary proceeding is on a
it
different
is different,
footing.
but on the ground of misconduct, my lord, I say, my lord, whether it is misconduct or not, my lord, that would be, my lord, an action which would not involve any
Misconduct on a, in fact, Mr. Rai, if you take our this misconduct, professional misconduct is on a higher footing, the higher standards than the conduct has to be on a higher standard than the disciplinary proceeding. In a disciplinary proceeding, it has to be seen whether I have derelicated my duty and neglected my duty and these things. But when I'm a professional, I'm representing the entire profession.
so, my lord, the duty
So
is
the
far more.
conduct duty is far more. Therefore,
Duty is far more. That is what I'm trying to submit, my lord.
I mean, it's on a higher footing. Your conduct should be on a higher footing.
That is
So you
what
have an easier job to say that you are in professional
so
misconduct.
that is what I'm saying, my lord. That is why I say
This
this might be-
dilutes, rather dilutes. I mean, disciplinary proceeding is habitual. So very well, mens rea, on the mens rea point.
on a mens rea, my lord. My lord, this is on mens rea. Then, my lord, misconduct, my lord. Give me 2019 11 SEC. 95 की church को. And this is 1995. Hmm. 749. 6 Supreme Court cases, 749. This is the realms of administrative law, my lord. And it kindly takes paragraph 9 and 10. And kindly takes 10. The ratio in L, Calra project and equipment has no application facts of this. Therein, the misconduct alleged was failure of the appellant to refund the advance taken from the corporation. His omission was charged with to be a misconduct. The question there was that when Rule 5 of PEC employee defines specific misconduct, whether in the general norm of behavior, the omission to return advance amount, which was not specifically defined, would constitute a misconduct. This court held that in the grey area is not amenable to disciplinary action unless the act is constituted a misconduct. Rule 5. We therefore hold that a public servant in possession of assets disproportionate to his known source of income, not satisfactorily accounted for, commits a misconduct amenable to disciplinary action under CCS rules and provisions.
How does this help you?
Well, only the point that misconduct. I'm as a matter of fact referring to Malad.
Here, there was a specific definition.
But Malad, it was also held, Malad. Kindly sees, Malad, in the last Malad.
Rather, it was held that in the grey area, it is not amenable to disciplinary action.
After that, your lordship kindly sees. Just after that, Malad.
That this therefore does not tally, actually.
Malad, that is the Malad. The last paragraph is what is Malad? Last sentence, Malad. They did not agree, Malad, with A.L. Kalra and said that hold that even if it is not there, therefore, Malad, it can be a misconduct. I am reading it in terms of section 22, Malad. Because, Malad, even if it does not fall, which my learned friend was trying to say, it does not fall within schedule 1. But he did not, as a matter of fact, discuss section 22 at all in his submissions, Malad. Though, Malad, your lordship had pointed out, but I have not recorded any submission from Mr. Mitro about what is his comments on section 22. 19 तक बात देखिए.
This is not a good judgment on misconduct in general. That refers to a particular rule. Rather, where it
Well-
differs from the rule, it says if there's a gray area, we have to go by the rule.
My lord, may I then refer to another judgment, my lord?
Hmm.
2019 11 Supreme Court cases 785.
Yes.
A very small judgment, my lord. May I just very quickly?
Hmm.
Leave granted 2, my lord. What has been pleaded before us is that the matter has ultimately been settled with complainant and chartered accountant, despite which the disciplinary committee took up the case. Ultimately found that the conduct of respondent was derogatory in nature and highly unbecoming, held in guilty of other misconduct under section 22. Read with section 21. The Council of the Institute of Chartered Accountants in India therefore made its recommendation to the High Court to remove the aforesaid chartered accountant period of 6 months from the rolls. High Court by the impugned judgment after setting out sections 21 and 20 of the Act, arrived at the conclusion. The instant case, respondent was acting as an individual in
This is also not German. See paragraph 5.
this it was entitled to under Schedule 1, Part 4.
We expected some sermonizing sort of thing regarding what is misconduct. No,
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 Malak,
done that.
but-
Somebody should sermonize. Then we will. If nobody else has done, we will.
This is section 22.
What should be professional misconduct?
I'm on section 22, Malak. This Malak fell under section 22 as other misconduct.
Who knows better what is professional misconduct than the judges? Because we have some immunity, so we can go up to some amount of misconduct without getting hauled up.
But I was only this Malak.
This judgment is not real. I will rely on the entire judgment. I will say you rely on the entire judgment. Does it help you more?
But I am on because one of the charging sections were sections 21 and 22.
Only that is the common feature.
Yes, well, there
There's a short story by Buddhadev Guha. One Modeda was there. He used to write
yes, yes,
poetry. And just because, say, the first sentence ends with Dontanna and the second sentence ends with Dontanna also, although those do not rhyme, he used to think that is poetry. The 21 and 22 were the search terms. You searched with 21 and 22 and you found this out. You never went through this judgment yourself, so
No, Malad, I was only,
don't elaborate on that too much. Which portion is relevant, Mr.
no, Malad, I am only Malad. I was trying to read section 22 with other professional misconduct. Your Lordship sees
Whether or not related to his professional work has been highlighted here. And
Yes.
your allegation is purely on professional
so
work.
Malad, that is on a higher pedestal.
So what?
That's no, I am saying
Material.
if it is not mentioned in section 21, section 22 can be
The
resorted.
ratio here is even if it is not related with professional work, then also it comes within misconduct. In your case, the entire allegation is on professional work. So how is this judgment German?
May,
Ask
one,
Mr. Gupta. if
only
you-
one sentence, Malad, Your Lordship. Malad, I say Malad, because Your Lordship remembers this is coming from what my learned friend has said, that part 3(1) has not been fulfilled. I say, Malad, that even if it is not fulfilled, under 22, this falls under professional misconduct. And here, Malad, section 21 and 22 were taken into contention.
Yes.
And under 22, Malad, even works which are not professional, that was also referred. That is what I want to say, Malad, that the income.
That's there in the statute. That's why it was referred.
But I'm just showing the scope, how it has been dealt with, Malad. That even works beyond professional.
The citation of this judgment does not pertain to professionalism.
But I understand. I'm only showing the scope, Malad, of section 22. That it's even beyond professional misconduct.
Go on to the next.
That is it.
Not a single judgment you could find out where misconduct, what is professional misconduct regarding any profession has been dealt with by the Supreme Court.
But there
Must
are
have been many.
There are many, Malad, but I thought, Malad, the scope of this act itself is so lucid, Malad. I thought that I don't need to, Malad. But
Yes, you have
whatever.
given specific charges under specific provisions. So need not go into that
That is
also.
fine. And Malad,
So these are the two judgments on what is misconduct.
yes, Malad. One more.
1979 showed for mens rea.
Ah.
Misconduct is also defined here.
না এটা দেখার দরকার নেই, ওটা আছে আর এটা দাও তো আমাকে একটু না
And rather in one of the judgments you cited, Mr. Wright, has been said, if it falls into the gray area unless it is covered by the section, should not be.
That is why I showed now the Chartered Accountant Institute Act, where it's saying even if it is beyond.
You have relied on the act itself.
Yes, well, again, my let I say, but because Mr. Mitro said, I'm only trying to counter that if it does not fall under part 3(1),
Yes.
then also it will be a misconduct under 22.
Achha.
I-
You have cited 22 also in the chart.
That is why that was 22.
Yes.
That is why I'm saying, well, I'm taking my worst case and trying to
You
show.
have cited the act on that.
I cited the act also, my lord. But because this was on that act, I showed this judgment.
Any other judgment on this act in general?
No, my lord. There are many, my lord, but I thought, my lord,
Precisely. That was supposed to be ironic.
there are, my lord, two are already on record.
What other
Justice-
judgment you quickly
Justice
cite your judgment?
Biswas and Justice Dipankar Datta, that's already
What
on
do they say?
and the prima facie opinion and things like that. When do you have to form a prima facie opinion, whether it can be challenged or
Not even argued by Mr. Mitra.
Well, Mr. Mujumdar was attempting to go that way, then he retracted of it. Well, this
Must have been some stimulus
একটু রোগা রোগা
for
নেই কিছু?
retracting.
একটু রোগা কিছু নেই দেখো রোগা দেখো একটা 2007 4 এসেছে yes
You'll change the judgments you'll cite. Why are you looking at it?
no man he wasn't keeping well so I just
Oh, sorry.
I thought that he has come to court so that's why. What's the matter about it?
Yes, but my cold, bad cold, very bad cold. Today I'm much better.
No, but there are. Let us see.
Yes. Sir. Hi, anyway, Mr. The Kaur will then submit it after the complainant is
Mr.
Joydeep Kaur had appeared
Oh, Mr.
for the
Kaur.
complainant.
God is leading me, my lord.
Achha.
I will.
Yes, Mr. Rai, then
Well, no,
finish quickly.
I'll show one judgment 2007 4 Supreme Court cases 502 502 দিচ্ছে তো তোকে সব দিচ্ছে তো নে para 18 to 20
Hmm.
and the meaning of the word include my lord. In a definition it is extensive and wide in its purpose my lord. '18 and 20. Meaning comprises of and consisting of. And
The judgment
extensive,
basically says includes means includes.
but not extensive. Includes means includes.
Yes.
But section
We
20,
also believe so. Includes means includes.
because the definition says so.
Includes is inclusive
Includes has
and
to
excludes is exclusive.
exclusive.
So these are propositions of law. I mean, which have evolved over a period of time.
I just showed one that is section 22 may I just read it and I'll finish my submission.
Finish whatever you have to.
Just one section 20.
Section 22. Yes, yes.
And after that
You have read that. Very well. Read it.
once. For the purpose of this act, expression professional misconduct shall be deemed to include any act or omission specified in any of the schedules, but nothing in this section shall be construed to limit or abridge in any way the power conferred or duty cast on the council under subsection 1 of section 21 to inquire into the conduct of any member of the institute under other circumstances.
Very passionate and expressive.
The reading, Malad? I
Yes.
thought the section was also.
No, the reading. Section is absolutely, I mean,
Those are my submissions.
thank you very much, Mr.
I'm very grateful.
So it was very precise and thank you for that. I mean, actually.
Grateful.
My lord, with regard to the, my lord.
Mr. Kaur.
Mr. Kaur, my lord, he just
But,
under. My lord, he's.
may I just request your lordship to kindly,
Oh.
my lord, keep it next Wednesday. I'll not take more than 10-15 minutes because
You need not assure us on that for the adjournment.
the problem is
If you are
that
asking for an adjournment, definitely they have no objection then. So we'll just adjourn it to the next.
Mr. Mitro will respond. right?
Mr. Mitra.
Should I find out about his availability?
Mr. Kaur, you are for the?
I am for the complainant, my lord.
Right.
In fact, I have very short submission. So
Right.
far as the merit of the matter is concerned, adjudication process, etc., I would not join issue. I just want to, Lord, point
Mr.
out.
Kaur, since you are appearing and since we are adjourning the matter, just ponder over this issue also, that why did you, withhold the the complaints, the papers which were there before the other authorities?
Lord, I shall
Oh no,
not
I'm sorry, the
address-
respondents did.
No, I did not withhold.
Your lordship did
I
that.
did not withhold.
I
Right,
did
right.
not, madam. We have
We
taken-
never got a chance to
Rather,
deal.
it's the other way around.
Yes,
It's a mutual chance.
we never got a chance to, Lord, look into those documents which were produced.
Those were withheld, yes.
Yes,
Right.
Lord, we didn't have a chance to deal with those documents.
So we'll keep it next.
Yes, he is okay. Next
Right.
Wednesday.
Heard learned senior counsel appearing for the Chartered Accountants Institute. On the prayer of learned senior counsel appearing for the complainants stroke respondents, comma, the matter is adjourned till August 13, 2025 for further hearing.
Much obliged.
Grateful, lordship.
এটা আগের দিনের নোটস কিছু আছে এর মধ্যে?
Both the matter.
Both item number 1 and
Matters,
2,
হ্যাঁ,
both the
matters.
matters.
Plural হয়ে যাবে।
I am for the appellant, but I had already concluded my submissions. Is on the only on the small point, the point of maintainability of the suit by virtue of the provisions, specific provisions contained in the act, that no civil action can be entertained when a matter is pending before the Tika country.
এই নোটস গুলো দাও।
But I have not made any submission on merit. I have only made submissions on this point of. My learned friend wanted to make submission on this point. If this point is.
No, my lord, if my learned friend wants to also address on the merits, I'll be happy to answer. But my lord, if my learned friend wants to confine himself only to the question of my lord,
He confined himself to maintainability.
Very good.
Yes.
No, no, it's not that I am giving up my right to make any submission on
But
merit.
you don't have any other opportunity to. If you want to address on merits, you can.
That I can.
Because
But
once you conclude arguments, then we won't let you argue, reopen the arguments on merits. Then you will be only replying
yes,
to Mr. Shah.
that is so, my lord.
You are the appellant. Whatever grounds you challenge this judgment on, it's open for you to challenge. You have taken only this section 21 bar.
Yes, I had taken that section 21 bar.
This was against what? Just remind us once.
My lord,
Thika tenancy.
Thika.
My lord,
my landed
I am
filed a
the
suit for
landlord.
eviction.
I had given out the property on lease,
Yes.
my lord, for a petrol pump. My learned friends, my lord, contended that they were Thika tenants under the 1981 Act.
That dispute came up and therefore it
And
has
my
to
lord,
be
that
referred.
dispute came on. Now, my lord, in 1995, I filed the suit.
No, let us ascertain first whether your learned friend will address on some.
Yeah, my lord.
My lord is correct, but I did not get myself to that extent ready to make any submission
you-
on merit.
On the last occasion, you made it clear that you were
I
raising
didn't
that
make any
point
submission,
only.
only on the point of maintainability. my lord,
Let us
I-
hear Mr. Shah on that. Yes.
Yes, let him.
My learned friend, my lord, talks about, my lord, the bar under section 5(3) of the 2001 Act. Now, my lord, the 2001 Act, my lord, came into force on 1st March 2003.
First March 2003.
Yes, 1st March 2003, my lord, it received the assent of the president and my lord, of the governor, and my lord, it came into force. And thereafter, my lord, this section 5(3) was amended again in 2010.
Yes.
Now, my lord, it is, my lord, the provisions of the 2010 amendment that have been shown to your lordship to suggest that the civil court would have no jurisdiction to decide on, my lord, matters concerning, my lord, as to whether, my lord, the, my lord, person is a Thika tenant and the land is a Thika land. That is, my lord, essentially the argument. Now, my lord, this, my lord, assertion, the assertion that was made by my learned friend, my lord, in his written statement filed to the suit, was, my lord, he is a Thika tenant under the 1981 Act. My lord, that is, my lord, paragraph 4 of the written statement. I can just, my lord, read that, my lord, paragraph once. Just one paragraph will suffice. That's at page 19 of the paper. Just one paragraph. Yes, yes. With reference to paragraph 7 of the and the various sub-paragraphs thereunder of the plain, the defendant states that by a letter dated 12 July 1892, should be 1982, this defendant,
This is application.
volume 1, paper book, first one.
পেপার বুক রয়েছে যখন পেপার বুক দেবে সবসময় মেমোটা দিয়েছে কেন পেপার বুক থাকলে অলওয়েজ পেপার বুক দেবে
Page 19.
yes paragraph
Just few lines of the paragraph.
yes
Defendant states that this defendant inter alia contended it should be that the suit land had been acquired by and vested in the state of West Bengal under the Calcutta Thika Tenancy Acquisition and Regulation Act 1981. Well, that is all that I need to show you, Lordship. So, well, they are claiming a right under the 1981 Act.
Page 20. My order.
And well, also, my learned friend, my lord, correctly points out at page 20, if your lordship sees, well, ultimately, my lord, this is what my learned friends accept and admit. That, my lord, by a judgment on order of special bench of this honorable court, well, it was held that my lord, Act has no application
This
to
page?
petrol pump. 20. Next page.
আচ্ছা yes specially
Well, this is the Lokhimoni Dashi judgment. Well, it does not apply to petrol retail outlets. Well, this is their case in the written statement. Now, my lord, so far as this is concerned, now, my lord, coming to the question of bar.
yes
Well, if your lordship will now kindly have a look at, my lord, section 531 as it stands amended. Well, this is what my learned friend relies on. Well, may I, your lordship have the book?
yes 2019 edition so
Well, please see section 5.3. Well, this is what my learned friends rely on.
yes
If any question arises as to whether a person is a Thika tenant or not, or whether the land in question is Thika land or not, the controller, then will either on his own motion or on receiving information, etc., may inquire upon and decide such question. So, well, this is where, well, the High Court's jurisdiction is stated to be, well, ousted or civil court's jurisdiction. Now, my lord, we'll kindly have a look at section 21. Well, this is in the context of section 5.3, the bar of jurisdiction.
yes
May I read this? No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or the appellate or other authority specified in the provisions of this act, and no order or judgment passed or proceedings including the execution proceedings commenced under these provisions of the act shall be called into question by any civil court. This is the bar of jurisdiction that follows 5.3. Now, we'll kindly have a look at section 27.
Yes.
It says, with effect from the date of commencement of this act, the Kolkata Thika and other tenancies and lands acquisition and regulation act 1981 shall stand repealed. But notwithstanding the repeal of the said act, such repeal shall not affect the previous operation of the said act or anything duly done or suffered thereunder, or affect any right, privilege, obligation, or liability acquired, accrued, or incurred under the said act, or affect any penalty, forfeiture, or punishment incurred in respect of any offense committed under the said act, or, this is most important, affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid. And then it says, and any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and any such penalty, forfeiture, or punishment may be imposed as if the act had not been passed. So, this is the saving provision. This says that today, if a legal proceeding, amongst other things, has been initiated, then there is no bar to its continuance. And this suit was filed in the year 1995.
It was 95.
Yes. And interestingly, this question is something that was ultimately raised before the learned single judge, and finds reflection in the judgment. The judgment starts. May I just show you, Lordship, the portion of the judgment. That starts at page 60. At page 66, if your Lordships will have a look.
Yes.
Please see, here reference is made at the bottom of the page, the last paragraph, to the case of Shobita Rani Majillo.
Right.
The question before the division bench was whether the Thika controller had jurisdiction to decide Thika tenancy right of any other person who allegedly filed return under the Calcutta Thika Tenancy Other Tenancies Act 1981. Such question was answered by holding that a proceeding initiated in respect of a return filed under the 81 Act was waived under subsection 2. Now, this judgment says a little more than what has been noticed by the learned single judge. May I just show you, Lordship, this judgment once. This is reported in 2011, volume 3, Calcutta High Court Notes, page 532 copy. Kindly give me a moment, I shall hand that over. Good evening. 534. Sorry, আরেকটা কপি trying to find the second copy.
Yes,
May I just hand up
give
the...
one copy in the meantime.
Yes, I've got the...
I have the other.
No, I've got it, Malad. This is very embarrassing.
No,
Malad,
not at all.
looking for the judgments, Malad, when Malad in the midst of
No,
argument.
you have found it also on the device also.
Malad, may I just read this judgment? Malad, this is a division bench judgment of our court. Malad, may I just read paragraph 4?
Yes.
Well, I hope the paragraphs match. It starts with the word in the writ application, a positive question. Yes. Yes. In the writ application, a positive question has been raised about the jurisdiction of Thika controller to decide Thika tenancy right of any person who allegedly filed return under the Calcutta Thika and Other Tenancies and Land Acquisition and Regulation Act 1981. By the said Act of 1981, the Calcutta Thika Tenancy Act 1941 was repealed. Under the earlier Act of 1941 as well as the Act of 1981, there is no provision for determination of Thika tenancy right by adjudicating lists in between the owner and the alleged Thika tenant by the Thika controller. Such power of adjudication to determine Thika tenancy has been brought in statute, being Act of 2001, which is named as the West Bengal Thika Tenancy Acquisition and Regulation Act 2001. The relevant section is Section 5.3, which was substituted with effect from 1st November 2010 by the West Bengal Amendment of 2010. Section 5.3, my lord, as amended, my lord, reads as follows. I will not trouble your lordship. I have just shown your lordship that section already. Then your lordship will kindly have a look at paragraph 6. The condition precedent of filing the return is vesting of land under Section 5. You want me to read? Well, paragraph 5, my lord, I should read once. Since there was no provision earlier to adjudicate Thika tenancy right, civil court had the jurisdiction to determine it. It appears from the document as filed before us, particularly the order sheet of Thika controller, with reference to case number such and such, that the concerned case was initiated on the basis of the return filed by the respondent number 5 in terms of Rule 3A of the Calcutta Thika Tenancy Acquisition and Regulation Rules 1982. Then, my lord, paragraph 6. The condition precedent of filing the return is vesting of land under Section 5, Chapter 2 of the said Act of 1981 to the state. Under Section 6 of the said Act 1981, Thika tenants' occupancy status came under the state in view of vesting of land under Section 5 of the said Act. Since from the records it appears that the proceeding initiated in the year 1982-83 on the basis of return filed by respondent number 5 and adjudication made declaring the respondent number 5 as a Thika tenant by the Thika controller, though Thika controller at the relevant time had no jurisdiction under the Act of 81 to adjudicate the issue, the impugned order before the learned tribunal passed by the Thika controller on 31st January 2008 is an order without jurisdiction, and as such it was a nullity and has no effective force. Jurisdiction goes to the root of the matter. The jurisdiction to adjudicate the Thika tenancy right by the Thika controller was granted under West Bengal Thika Tenancy Acquisition and Regulation Act 2001 by subsection 3 of Section 5 in the following language. Then I will not trouble you with language. Then by Section 7 of the said Act. Well, by Section 7 of the said Act of 2001, with effect from the commencement of the said Act of 2001, that is 1st March 2003, the Calcutta Thika and Other Tenancies and Land Acquisition Regulation Act of 1981 was repealed, and proceedings initiated prior to coming into effect of the said Act 2001 under the said Act 1981 were saved by a non-obstante clause under subsection 2 of Section 27 of the Act of 2001. Then, well, Section 27 is reproduced. I will place that section before your lordship. Then paragraph 7. Since in the instant case return filed under the Act of 1981 by the alleged Thika tenant, respondent number 5, and the case started registering the case of the year 1982-83, though the adjudication made subsequently after 1st March 2003, declaring the respondent number 5 status as a Thika tenant, but as the proceeding as was initiated under the Act of 1981, such proceeding was saved under subsection 2 of Section 27 of the Act of 2001. As such, the impugned decision before the learned tribunal below passed by the Thika controller was nothing but a decision exercising power to adjudicate an issue which never was vested to him under the statute, namely the Act of 1981. My lord, this is, my lord, the first of the judgments, my lord, in this regard. My lord, then, my lord, there were two, my lord, orders passed by a division bench of Justice Jyotirmay Bhattacharya. The first is rather cryptic. My lord, that was taken up in review. My lord, there was a review application filed for that. I'll show your lordship the judgment of the in review. My lord, this is, my lord, migrating from the year 2011 when, my lord, the Majillo judgment was passed to, my lord, 2016. I forgot the judgment already. No, the judgment.
This was an eviction suit, eviction of a tenant.
Yes, sir.
The section 8 is also there, but that is also of the 2001 Act.
Yes.
The same regards apply. And 2, which says that the controller has to pass eviction orders, that is also, that came in the year 2010.
That's it. And this, my lord, of course, is saved by section 20, subsection 2.
Yes, saving clause.
My lord, I just want to show you a review. Yeah, I'll just give my learned friend a copy of this because
Yes,
this is
yes.
not, my lord, reported, it seems. It has Jyoti directed. I think. Well, this is again a division bench. Well, this application for review was filed by the respondent number 5, praying for review of the order passed by this court on 4th June 2014 in such and such on the grounds mentioned in the review petition. It is stated that the order passed by this court on 4th June is required to be reviewed in light of the provisions contained in section 5, subsection 3 of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001. According to the petitioner, under the provisions contained in section 5(3) of the said act, exclusive jurisdiction was vested with the Thika controller for deciding an issue as to whether a person is a Thika tenant or not, and or the land is Thika tenancy land or not. It is further contended that section 21 of the said act imposes a bar on jurisdiction of the civil court to decide any issue which is required to be decided by the Thika controller and or its appellate authority. Mrs. Ghosh, advocate appearing for the review petitioner, submits that since this court, while disposing of this tribunal application, considered the issue involved therein in the light of the decisions of this honorable court passed under the old act, that is the Calcutta Thika Tenancy Acquisition Regulation Act 1981, though at the relevant time 2001 Act came into operation, the order passed in the said tribunal application on 4th June 2014 is required to be recalled, and the issue involved in this tribunal application is required to be reconsidered in the light of the provisions contained in the 2001 Act. It is rightly pointed out by Mrs. Ghosh that under the 1981 Act, jurisdiction to decide such a dispute was not vested with the controller, and such dispute was required to be resolved before the civil court. But under 2001 Act, such jurisdiction to resolve the dispute as to whether a person is a Thika tenant or not, and or the land is a Thika tenanted property or not, was vested exclusively with the Thika controller under section 5.
Just now we have seen it, page 4, the second last paragraph.
Yes, ma'am.
And then Kole Properties
That's
has been referred to.
That's it.
That's another division bench, which we don't.
Yes, my lord. And my lord, finally, my lord, a more
Same.
recent judgment.
Acha.
My lord, of course, that is a single judge, my lord, of this court.
Yeah.
But my lord considers the entire matter, my lord,
Yes,
from the perspective. My lord, that is, my lord, a judgment of 2024. It was decided on 13 June 2024 by this court. I'll just hand up that, my lord, judgment to your lordship. Well, I'll not multiply any further judgments. I think this ultimately, my lord, takes care of the issue. My lord, your lordship will kindly straight away, my lord, come to issue numbers 1 and 2. তোমায় দিয়েছে copy? না না এটা একটা copy দাও তো দিতে। Well, at paragraph 15, your lordship will see this is the issue. Well, whether the suit is maintainable in view of the bar of jurisdiction of civil court imposed both by the Act of 81 and 2001. And well, so far as this is concerned, this issue is finally taken up. Well, your lordship will find from paragraph 17, 18, and 19, the sections are reproduced. Then, my lord, all the judgments, my lord, are considered, and finally, para 25.
Yes.
My lord, ultimately, my lord, the language of the statute itself is clear. My lord, we really need not go anywhere. My lord, this is saved. And my lord, the specific case was, I am a Thika tenant under the 1981 Act. My lord, proceeding started, my lord, for eviction. His defense was, I am a Thika tenant. I cannot be evicted. And my lord, that was the only defense. And my lord, that is what was decided. My lord, this matter took some time because, my lord, the issue as to whether, my lord, retail petrol outlets are covered or not, my lord, was settled by our court in Lokshimani Darshan. But thereafter, my lord, there was a stray judgment of the Supreme Court. My lord, Justice Mukhopadhyay's judgment, my lord, which upset the whole apple cart. That, my lord, was reviewed by the Supreme Court, and my lord, that review took some time. Then, my lord, in review in the money properties case, Supreme Court had said, no, that is a wrong judgment.
So petrol pumps are excluded. It's a petrol pump admittedly.
Yes, well, this is a petrol pump, admitted. Thika tenancy usually kacha structure, cattle, khatals, etc.
Show him his return.
Do you want to cite that judgment also?
Yes.
So that takes it one.
I can,
But since you're taking a point of, because
No, no,
jurisdiction,
if I can, my lord, hand it up to your lordship, because, my lord, the point is now, my lord, finally settled by the Supreme Court. I just want to hand it up to your lordship, because, my lord, there's no controversy about whether, my lord, this is, my lord, my learned friends are Thika tenants or not. That controversy
that
is
takes your argument one notch higher because
yes.
the dispute is not there.
Dispute is not.
If it's settled by the Supreme Court, then it's
Yes, my lord, it is, my lord,
probably it's
finally
not a
settled.
dispute within, also not a dispute.
Yes, my lord, it is finally settled, my lord. I shall just hand up the judgment to your money properties again. Supreme Court case, then it will be ঠিক আছে বলছি। ঠিক আছে, এটা কপিটা এটা দুটো সাইডে প্রিন্ট করেছে কেন? তুমি সাইটেশনটা বলে সাইটেশন। Well, here, my lord, this is
Need not refute.
my lord, Nimai Chandra Kumar versus Money Square Limited. Well, I'm a little embarrassed, my lord, because this judgment, my lord, has been printed on both sides of squid. My learned friend was being my lord, saving the planet. So, my lord, I'll just hand up, my lord. Lordship will kindly forgive me. I'll just hand up a copy of this judgment. My lord, this is Money Square judgment. Money Square. My lord, Nimai Chandra Kumar, that's Money Square. This settles the issue finally. Supreme Court. Supreme. You're growing old. No, not at all. Also, it's going old. Citation to give him. Well, I'm extremely sorry, my lord. I'll make 2 copies available, my lord, to your lordship's office. Yes. My lord, this is, my lord, all. There's nothing more to the matter.
Yes, what do you say?
I will give a reply to this, my lord. That's not possible today
Why not?
because I have also not equipped my books. There's the problem.
This is the only point involved.
I know, my
Have
lord.
been prepared.
Even then, my lord, give me 1 day time.
Heard learned senior counsel for the respondents. Question on the prayer of learned senior counsel appearing for the appellant. Heard learned senior counsel for the respondents. Question on the prayer of learned senior counsel appearing for the appellant. The matter is adjourned till August 13, 2025 for conclusion of hearing.
কি হলো? কি হলো?
My lord, may I hand up, my lord, 2 copies of this judgment?
Yes, we are just returning this.
You lordship can retain that triple
because
lordship
they-
market. I'll just make
You
my-
give another copy, one
I'll-
copy.
Yes.
अरे आगे থেকে বল না জিনিসটা my lord, I feel very hesitant to tell your lordship, my lord,
Yes.
That my learned friend, both of my learned junior also, my lord, is requesting me to pray to your lordship to do it on 27th.
No. No. 13th. 13th. 18th. You contact your advocate in the Supreme Court before that.
Lord, kindly recall, my lord, yes. My lord, this is 16 number of review as well as stay application passed by one of my lords. And my lord, this
Singly?
is- No.
Sitting singly
sitting division.
with Justice Kumar.
Yes. And
Yes,
my lord,
Nando, please.
yes, my lord. And my lord, one thing, my lord, that is another, my lord, this is the interesting point is being involved here, my lord, because my lord has actually set aside the order. That's why, my lord, review application has been filed. All those review application, same one order, my lord, that
Right.
is up, and my lord, another, my lord, that is second appeal. It is not till date, just it has to appear. Second appeal.
Not admitted yet.
No.
For admission hearing. Please write for order 41 rule 11 and then. Yes. What is the matter? Hearing. It's a hearing matter. Well, hand over. Hand over. Yes.
On Monday, I mentioned a matter for release. The matter is appearing in item number 3 as in the today's release. The number which I have mentioned in the list was wrong. This is my fault.
Order 41.
You had mentioned for release.
My lord, on the mentioning slip, I have mentioned a wrong number. My lord. The matter is appearing as item number 3 today.
When the matter is called on, please respond and we'll just.
Sir, may I hand over the corrected slip for release? Corrected one.
Very good. Yes.
Sir, may I have your lordship's kind leave my lord to file an appeal without a certified copy thereof?
Yes.
Brief.
My lord, may I be permitted to mention one matter for inclusion, my lord?
What is the matter? Application or hearing or what?
Mandamus appeal group 1
Yes.
for inclusion.
Order 41 rule 11, my lord.
Yes.
So order 41 rule 11.
Yes, please. Application.
Your lordship, may I be permitted to mention a matter?
1 minute. FAT, we don't have determination now. First appeal, regular first appeal, we don't have determination. Justice Shane has determined. We have only land determination, group 1.
Lordship, may I be permitted to mention a matter? The matter pertains to pension. So,
Pension, do we have determination?
Your lordship, it is an order which has been passed by the learned third additional district judge Alipur. So we are filing under order 41 rule 5.
Order 41 rule 11, yes, yes.
Lordship, for hearing and inclusion in the list.
What is the matter?
Appeal, FA. First appeal, FA.
First appeal, we don't have determination.
Paper book is filed.
We don't have determination. Yes, call on the list.
Lordship, item number 1 and 2, I am praying for eventual lordship for correction the name of the advocate of the appellant, eventual lordship.
What should it be?
In place of Swarnava Sarkar, lordship, it should be Swapnomay Sarkar.
Give the correct.
Yes, sir.
In the judgment dated August 4, 2025, comma, in the list of appearances of advocates on behalf of the appellant, comma, instead of Mr. Swapnabho Sarkar, comma, the name was transcribed as Mr. Swarnavo Sarkar, full stop. Let such order be deemed to stand rectified by this order.
লর্ডশিপ স্বপ্নময়
স্বপ্নময় স্বপ্নময় ওই যেটা বললাম স্বপ্ন কি বললাম ওটা বললাম স্বপ্নময় হবে yes yes
My lord.
so this is
Wrongly
the number wrong number was
This is not
acha
my
what is the correct number
But I have given the slip, my lord.
देखिए ओटा
SA 127 of 2020. The cost title was right, my lord, but the number was wrong.
learned counsel appearing you are for the appellant in this that correct number learned counsel for the appellant in SA number 127 of 2022 submits that erroneously comma he had mentioned he had given the present number of SAT 144 of 2022 in the mentioning slip for which the said matter is appearing wrongly. So accordingly, let SAT 144 of 2022 go out of the list and SA number 127 of 2022 be listed under the heading to be mentioned for release.
May I give my name?
Huh?
May I give my name?
Yes, yes, give your name. Give your name, but write there that appellant on behalf of appellant in the correct number.
My lord, I am for the petitioner, my lord.
My
My
lord,
lord,
can I,
before inviting,
am I seeking a short passover in this matter as my senior learned counsel is busy, another court.
Yes, you are saying something?
yes, my lord, before inviting, my lord, the impugned order of the West Bengal Tribunal, Tenancy Tribunal, I should, my lord, narrate the fact in a
So let us wait for 5 minutes. Let her senior come. Passover, it a Passover third.
Oblige, my lord.
Thank you. Please inform whenever his senior comes, inform your learned friend, and so that we can call the matter after the matter which is going on.
Okay.
This is my application. Okay.
Yes, please.
This matter.
You're for the other side.
Well, yes, my lord, on behalf of the
Yes.
private respondent.
No, minute, in this matter, minute, this is concerning a Borgadar. Now, this Borgadar, he says in his application before the PLLRO that he was.
Take the microphone a bit closer to you.
He was.
You're too tall for the microphone. Actually, take it up. Yeah.
He says that in 1978 he was dispossessed from sir.
You are the Borgadar.
I'm not.
Acha, the other side.
I'll just tell your lordship in a nutshell. Now, he says in his application before the BLLRO, in 2008 he files this, that in 1978 he was dispossessed. Now, in the meantime, this Borgadar, he buys the property from the erstwhile owners. And then he conveys that property to me.
This self-same property?
Yes.
Which year he bought?
In 1997. And the next day, he takes a premium from me. I'm his brother-in-law. And he sells by 2 registered deeds of sale. He sells 2 plots of land. These are the 2 plots
Which
of land.
year? Sale deed?
1997 December. I'll tell you, lordship.
29th December.
29th December.
97, my lord.
May I?
Yes.
I'll be 29/12/1997. He buys it from the erstwhile owners, and on the 30th of December he sells it to me by 2 conveyance deeds.
30th December.
Yes, 1 day later. Now, after that, in 2008, he comes up with an application that he should be restored possession. In 2008. Now, the BLLRO passes an order that he should be restored. His possession should be restored as a Borgadar.
You say that he lost his character as a Borgadar when he purchased and sold.
Absolutely. And again, but this is not what is before your lordship. This is not before your lordship. Now, after that, I go up in appeal, and the appellate order also confirms the order of the BLLRO. Then I go to
be restored in possession.
Yes. Then I go up before the tribunal. Now, the tribunal on the first day, it passes an order of status quo regarding the property. Now, I'm in possession. During that time, now after that, this matter again comes up one day, and because of the fact that I have filed a civil suit against this person for declaration and injunction, the court says, let it go out of the list. We both agree. Now, after that, what he does is, this Borgadar, this person, now he's no more the Borgadar, he now goes to the SDO and he executes the order of the DLLRO and he dispossesses me. Now, this order of status quo has not been, nothing has been done, because it was an order which was said that, okay, status quo till further orders. Now, your lordship knows that adjournment is not an order at all. Now, after that, I come up with 2 applications. One is for contempt and one is for restoration of possession. Now, if your lordships kindly take the impugned orders, what is happening here? That is taken up after almost 13 years.
So you took out the contempt and the restoration before the tribunal?
Yes.
So those have been dismissed?
Those have been dismissed.
Which is under challenge now?
Yes. And what is taken here is, the tribunal says that this person who had Mongol Bhangi, his name is Mongol Bhangi, he's dead by now. His successors have come in. They've been substituted, his heirs. So therefore, there can be no contempt against this person since he's dead. And secondly,
Possession was obtained by Mongol.
Mongol. There's nothing about purging. The tribunal even doesn't discuss.
Plus restoration, what is
And restoration, very strange order that it is now redundant because it is up for hearing.
Let us see.
If your lordship kindly sees that. No, the last.
First, please show us the status quo order of this tribunal.
Yes, Millard, I'll show your lordships. Page 61, Millard.
You are for the state, you are for the...
I am for the private respondent, my lord, substituted, my lord,
The heirs of the Borgada. State has been served.
Huh?
Yes, yes.
Yeah, yes, they've been served. If your lordship sees this, page 61.
61,
Yes. Now, about one paragraph from the bottom.
Yes.
On the prayer of the learned counsel on behalf of the petitioner, status quo as regards possession of the suit land be maintained till further order. Now, thereafter, your lordship kindly takes up page 166.
Yes.
This is the next order that I was talking about. Because this civil suit is pending, and now the civil suit has been decreed in my favor. Appeal is pending. Mr. F. Rahman, learned counsel, filed fresh Vakalatnama on behalf of the private respondent number 4, Mangal Bhangi. Let it be kept over the record. At this stage, on the submission of the learned counsel of both the parties, the matter be go.
Yes, yes, this was with the status quo.
Yes.
Obviously.
Now,
yes.
after that,
Yes.
if your lordship kindly comes to the report of the BLLRO at page 104.
Yes.
Yes. Towards from the bottom, Millard, I'm reading the second paragraph, about 3 or 4 lines from bottom. By all the aforesaid appropriate, page 104, Millard.
Yes. 104, yes.
Appropriate authorities, the purchase and sale deed number 558 dated so and so were not taken into consideration, and they opined in favor of the restoration of the recorded Bargadar Mangal Bhangi in the suit 2 plots. May it please be noted that from the recent field inquiry, it appears that the appellants were exercising their physical possession over the suit 2 plots up to the end of 1417 BS, and the recorded Bargadar Mangal Bhangi is still kept ousted from the said 2 plots. And then after that, if your lordships kindly see page 252A, page 149. If your lordship kindly comes to page 149.
No, therefore, till 12th of August 2011, he was still in.
Yes, I was.
Out of position.
Yes.
He was out of position.
He was out of possession because he says that in 1978.
No, you say you.
And I am in possession throughout. And that's what the BLLR also says. At 149, if your lordship sees. This is my application.
Yes. 149, right.
Paragraph 12. Knowing fully well of the order of status quo passed by the learned tribunal on 21/12/2010, in the said original application, private respondent, namely Mangal Bhangi, proceeded with the execution of the order of the concerned BL and LRO, and on 2/4/2012, the said private respondent, along with police, forcibly ousted the applicant number 1 from the disputed property unlawfully, illegally, and in willful disregard and disobedience of the order of the learned tribunal. Now, this is my allegation. Now, if your lordship kindly comes again to page 215 once, 214, there's another report of the BLLR.
Page 1 and
214. Yes. This is another report of the BLLR. This is a second report. This was filed before the tribunal. Now, if your lordship kindly comes to, it is held by the appellate authority. The lordship's got it.
No, where?
214.
Held, yes, it is held.
It is held by the appellate authority under section 54 of the WBLR that appeal fails to prove their case with valid and cogent reasons, so the appeal is dismissed. The order of the learned lower court is upheld and interim order of status quo is withdrawn. I don't know from where he gets this. It is held by the appellate authority under section 54 of the WBLR that appeal fails.
No, in the suit, in the suit, your injunction was.
Yes, that was, no, in the suit, I failed first. Then in appeal, it was granted till disposal of the suit. That is at page, I'll show you. Lord.
So appellate authority withdrew the status quo order, which was reimposed by the tribunal.
Appellate authority
order of
dismissed my appeal.
Upheld and interim order of status quo is withdrawn.
I don't know about that. That is, that maybe they were talking about the trial court's order.
Appeal under section 54, they are saying.
Yes.
So there was an appeal by you.
Yes, that was dismissed. That was dismissed. After that, I
withdrawal of the status quo in that. So which become redundant because it merged into, there was no withdrawal of status quo.
No. They
never got any status
quo.
No,
No, because it was dismissed. It was dismissed.
So before dismissal was.
And then after that, no. After that, I came before the
tribunal granted status.
Tribunal.
Different, yes.
Now I'm complaining about the violation of the tribunal's
that
law.
I understand. That we understand. But
yes.
Here it speaks about appeal being dismissed and order of status quo withdrawn and annexed.
Of the order of the lower court. Lower court means, Millard, where in the trial court.
Don't know, confusion.
Yes, Millard, the trial court. After that, in appeal, if your lordship sees the appellate order, that is 101 in the civil suit.
There you got
there I got the there I got the order. And now after that, after this, if your lordship kindly sees, on written request from the end of the officer in charge, Chandrakona Police Station, duly instructed by his superior authority with Superintendent of Police, Paschim Medipur, addressed to the Subdivisional Officer Ghatal, with his RT message dated 22/3/2012. The Block Development Officer Chandrakona 1 and the Block Development Block Land and Land Reforms Officer Chandrakona 1 to assist on the matter in compliance of the lower court's order, Xerox copy of the RT message, in turn as per oral instruction of the SDO Ghatal to the officer in charge Chandrakona Police Station, the BL and LRO Chandrakona accompanying with BDO Chandrakona 1.
You did not inform the BL about the status quo.
Everybody was informed. They were appearing.
Represented.
They were represented. The government also was there.
That is sufficient.
Yes. And after that, the last order, if your lordship sees, what happens? But possession could not be handed over to the incumbent concerned through possession, though possession was handed over subsequently on 2/4/2012 in the gracious presence of the Honorable Executive Magistrate Ghatal in order to make over possession to Mangal Bhangi, the recorded Bargadar. And accordingly, the entire situation was communicated to SDO Ghatal.
Yes.
And this is proof. In the meantime, the LR records, this is Borgadong and all that is pending before the tribunal.
This does not say anything. This says that
that is before the tribunal, so that has to be heard out. But I'm only talking about the contempt and the restoration of possession. Now, if your lordship sees, this is abject defiance of the order of the learned tribunal.
No, this does not record any other direction. It just records the narrative, whatever happened.
Yes, narrated that it was.
But this does not carry any further order that it should be implemented.
This is the report of the BLLRO.
Oh, then yes.
He says that the possession was handed over on 2/4/2012.
Where is that?
That is there, right? Page 215.
Oh, acha.
Yes.
Could not be handed over.
Yeah, first it was could not be
subsequently handed over. Right?
Yes, subsequently handed over. In the gracious presence of the Honorable Executive Magistrate. And then after that, my lord, if your lordship kindly reads the order, and this is also 252, if your lordship 252A, if your lordship sees once. I've just typed it out because this cannot be read, 252. Though 252 is carries the endorsement as to how I was dispossessed. (252A) kindly arrange to depute an executive magistrate, one revenue inspector, and one surveyor to comply the court order in CWBC execution number 1309 and BC case number 2508 on 28/3/2012 at 8 hours at Moja so and so, measuring 17.52 on petition of Mangal Bhangi. Now, after this, if your lordship sees, the kindly reads the impugned order once.
9th of April.
Yes.
It starts from 9th of April. No, 9th of April is that
5th March. Last certified copy.
no, 5th March.
5th March.
This is, we have 9th of April.
Delivered, yes, judgment delivered 9th April 2025.
Yes.
Yes. Now, my lord, let us take up first. Let us first take up MA number 490/2012. That is the contempt application. Now he goes on to say written notes and everything, and then after that,
490 is the contempt.
yes, contempt.
And 91 is the restoration.
Is the restoration application. On perusal of the order dated 21, now if your lordship sees the second internal page 2, the second paragraph.
Now, the disposal of the number 490 we can understand because he was dead.
He was dead.
Allegation.
And then after that,
Let us
491, if your lordship kindly comes to
page 3.
internal page 3. Close scrutiny was submitted after the hearing of both the parties and after going through the relief sought for in the original application being OA, it appears to us that the prayer made in the miscellaneous application 491 is quite in consonance with the relief sought for in the aforesaid original application, seeking an order to set aside the order of the appellate authority and DL and LRO, Paschim Medinipur, dated 12/11/2010, passed in LR appeal number so and so, and by setting aside the order of the
point out about the status quo.
Yes, everything. That is why that contempt was there.
That is not discussed here. Yes,
Nothing is discussed.
Contempt is there for that only.
Nothing is discussed.
While deciding the contempt, he must have discussed. Let us see.
No. That is also, he says that he's dead, so therefore there can be no contempt.
No. He records in page 2. They record. Middle paragraph, on perusal of the order dated such and such.
Yes. Learned representative, it is directed that the LR record, along with BC case, it was further ordered on the prayer of the learned counsel for the petitioner's status quo as regards possession of the suit land be maintained until further order.
He records that.
And it is alleged by the applicants in the end that
yes.
And then after that, if your lordship sees, more interesting is this one.
What?
As the original application, the last paragraph.
Yes.
As the original application is already admitted on 21/12/2010, and the LCR has been called for from DL and LRO Paschim Medinipur on the same date, the original application is ready for hearing and disposal exchange of affidavits. What about my restoration?
What about his restoration? Same question to you.
The
palpably bad or?
It's a bad, but the actually
contempt, yes.
But the actually the private respondent never disposes. He was in possession. That's why the status quo was admitted by the parties.
If you are not in out of possession, then how could you? Why? How was it application for restoration of possession maintainable?
Then the moment kindly visualize the position. On 29th,
it was your application for restoration of possession that initiated the entire proceeding.
The subsequently, in the year 2000, my learned friend says, I am out of possession since 87. 29th December 97, the so-called deed was purchased by my predecessor
and sold to him.
Sold next day, not which says lead is not that on that date, not yet perfectly completed the sale.
How can a sale be perfectly completed?
There must be on 30th December, one of the vendee of my predecessor signing that deed. Kindly have a look.
Have you challenged the sale deed?
That was under challenge. Is suit.
Have you succeeded there?
There is a injunction was there was an injunction. So I have been informed. Yesterday, an injunction was granted. There by the appeal court.
Maybe.
Kindly have a look.
No. See, you have obtained an order from the first authority, from the BLRO for restoration of possession. If you file for restoration of possession, implicitly you admit that you are not in possession. Otherwise, what can one seek if he is already in possession? You get that order, appellate court affirms that order, they challenge in tribunal, and they obtain a status quo order. In the interregnum, there was no execution, which is proved by the BLRO report, which says that on 2nd of April 2012, this order was passed, whereas the status quo order was obtained in 2010.
Yes, sir.
So after status quo order was obtained, you were restored possession. That itself shows that you were not in possession. Palpably bad order. We'll set it aside right now. We are rather surprised with this sort of order. But we stop there because we are now aware that our comments may have other repercussions. We'll set aside this order.
But a deed is otherwise. Kindly have a look.
The real culprit is sitting on your left side.
Kindly have a look once.
The real culprits.
Yes,
they initiated when it is really required. There is urgency, no execution, nothing happens. Whenever there is a status quo, the state becomes active state.
Kindly have a look. This once.
There are advocates in this court.
Page 32 is the deed.
Particularly 1 or 2 advocates. Yes.
32. Kindly have a look. Deed. This.
Should you have a look? Can you look into the deed? You file application for restoration, sir. That means you are not in. You are admitting you are not.
Yes, that's the real fact. That's the mistake on the part of
it's a single writ petition or 2 writ petitions? 1 writ petition.
Because there's a component.
The other component we are not.
That he's dead, so what can?
Right. Mongol Bhangi, that was the name.
Yes.
BHANGI.
Yes.
Your predecessor.
Yes.
Very well. Heard learned counsel for the parties. First up, in view of the short conspectus of the present challenge, the main application is taken up for hearing. First up, next para. Learned counsel for the petitioner argues that that one Mongol Bhangi, claiming to be a Borgadar in respect of the disputed property, purchased the property by registered deeds on December 29, 1997 and sold those to your predecessor or you? Sold to the present petitioner,
Osman Sarkar.
petitioners by different deeds on the very next day, that is on December 30, 1997. First up, next para. In 2008, the said Mongol Bhangi made an application before the concerned authority for restoration of possession on the allegation that he or she, Mongol Bhangi was a male, that he was a Borgadar. First up, next para, learned counsel for the petitioner submits that although such claim could not have been maintained, in view of the Borgadar having lost such status upon purchase of the property and sale of the property in favor of the petitioners, the said application was allowed, thereby directing restoration of possession to the said Mongol Bhangi. First up, such order was challenged in an appeal where the petitioners failed. First up, next para, against the order of the appellate authority, a challenge was preferred before the tribunal. First up, the tribunal, by an order dated December 21, 2010, granted status quo in respect of the disputed property. First up, subsequently, in view of the pendency of a civil suit which had been filed in the meantime by the present petitioners with regard to the self-same property, the matter was adjourned by the tribunal. First up, thereafter, on April 2, 2012, in purported execution of the order of the DLLRO in the appeal, whereby the Borgadar's whereby the eviction or whereby the restoration of possession or order in favor of the Borgadar was affirmed, comma, the petitioners were dispossessed in execution of such order. Full stop. Next para. Learned counsel submits that there did not arise any question of execution in view of the status quo order staring at the face of the parties on the relevant date. Full stop. Learned counsel places reliance on a BL and LRO report to substantiate his contention that in purported execution of the said order in favor of the Borgadar, comma, possession was handed over in favor of the said Mongol Bhangi. Full stop. Next para. Thereafter, comma, the petitioners took out two applications, comma, one for contempt of the tribunal's order of status quo by disposition of the petitioners, comma, being numbered MA 490 of 2012, and another application for restoration of possession, comma, which was taken unlawfully in the teeth of the status quo order, comma, giving rise to MA number 491 of 2012. Full stop. Next para. During pendency of the applications, comma, the said Mongol Bhangi met his demise and his legal heirs, comma, the private respondents herein, comma, became stepped into his shoes. Full stop. On the ground of the demise of Mongol Bhangi, comma, MA 490 of 2012 was dismissed by the tribunal by the impugned order on the ground that contempt was a personal cause of action and did not survive on the demise of the alleged contender. Full stop. Next para. However, comma, in the same breath, comma, the tribunal rejected the application of the petitioners for restoration of possession on the peculiar premise that the handing over of possession to the so-called Borgadar was quite in consonance with the relief sought in the original application, which was affirmed by the appellate authority, comma, thereby totally overlooking the status quo order passed by the tribunal itself. Full stop. Next para. Learned counsel appearing for the private respondents opposes the application and submits that there were certain faults in the sale deeds purportedly executed by Mongol Bhangi in favor of the petitioners. Your predecessor had sold.
My predecessor.
Mongol Bhangi had sold.
No, my lord.
His predecessor.
The Mongol Bhangi, the purchase deed of the Mongol Bhangi is, my lord, is defective, my lord.
It is further submitted that the purchase deed of Mongol Bhangi is also defective. Next para. However, comma, upon hearing learned counsel for the parties, comma, we are of the clear opinion that the veracity or legality stroke validity of the purchase deeds is not at all the subject matter of consideration in the present challenge. Full stop. The sole factum which was required to be gone into is whether the petitioners were dispossessed in the teeth of the subsisting status quo order of the tribunal dated December 21, 2010. Full stop. Next para. It is clearly substantiated by the BL and LRO report annexed at page 149 of the present application that indeed, comma, the petitioners were dispossessed on April 2, 2012 in purported execution of the order of the first authority, comma, as affirmed by the appellate authority for restoration of possession to the purported Borgadar, namely Mongol Bhangi. Full stop. However, comma, as on that date, comma, the status quo order dated December 21, 2010 was clearly subsisting and, comma, as such, comma, the parties were bound by the same and the said Mongol Bhangi could not take advantage of the restoration order which was in challenge before the tribunal, comma, and the tribunal was in season of the same, comma, in view of the status quo order restraining both parties from altering the status quo as regards possession. Full stop. Thus, comma, it was a clear case of contempt. Full stop. However, comma, since Mongol Bhangi met his demise in the meantime, comma, we do not find any fault in the tribunal having rejected MA 490 of 2012, comma, since no cause of action, no personal cause of action for contempt subsists on the death of an alleged contemner. Next para, be that as it may, comma, the learned tribunal acted palpably without jurisdiction and in a perverse manner in overlooking its own status quo order, comma, which was referred to in the earlier part of the impugned judgment itself, comma, by relying on the order of the first authority as well as the appellate authority in the original application for restoration of possession to Mongol Bhangi, comma, which was put in hibernation by virtue of the status quo order at the relevant juncture. Full stop. Thus, comma, the disposition of the petitioners, comma, purportedly in execution of the order of restoration was patently illegal and ought to have been purged, PURGED, purged by restoring possession to the petitioners. Full stop. Next para. Accordingly, we are of the opinion that the learned tribunal erred in law and without jurisdiction in dismissing MA 491 of 2012, full stop. Hence, WP LRT number 117 of 2025 is allowed in part, comma, thereby setting aside the portion of the said order whereby the portion of the impugned judgment and order dated April 9, 2025, passed by the West Bengal Land Reforms and Tenancy Tribunal in OA number 2955 of 2010 within bracket LRTT bracket closed and directing the possession of the disputed property to be immediately restored in favor of the petitioners. Full stop. The tribunal shall pass necessary directions of police help in favor of the petitioners for restoring such possession, comma, as at the earliest, comma, as and when so approached by the petitioners. Full stop. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of the certified copy thereof for the purpose of compliance. No address to cost.
Deeply applied.
Item number 6, I appear on behalf of the private respondent led by
এটা পড়ে যাবে বই এদিকে তাকান ওপরে yes
led by Mr. Supratim Dhar, learned senior advocate. My lord,
Supratim Dhar,
my lord, I'm seeking for a week's accommodation. Can you take up the matter on Monday?
yes, come.
আরে ব্রিফটা তো পেতে হবে।
You are for the whom then?
I'm for the state lordship.
And you are for the private respondent?
Private respondent, my lord, today, my lord, client has contacted us.
Client's fault, not their fault.
At least give us 2 days time only.
TODAYS.
My lord.
Yes.
Monday.
On the prayer of the private, we are adjourning for 2 days. On the prayer of the private respondents, let the matter stand adjourned till আজকে কত 6? No, then it has to be Monday till August. আজকে কত তারিখ? আজকে তো 6 তারিখ। শুক্রবার তো আমরা সিঙ্গেল বসি।
11.
2 দিনের টাইম চাইছে। Till August 11, 2025. Affidavit of service filed to be kept under. সোমবার দিন। Same heading এ থাকে। Please give the appearances, Mr. Ghoshan. Passover matter, both sides are there. So that was 4. Should we adjourn it for the day instead of keeping you waiting? Because 3:30 we have another. I have another bench, so I have to rise at 3:15. Well, let us take up the next matter in the meantime. Yes.
On the 7th.
Yes.
7, my lord.
Expeditious disposition.
I am for the petitioner, my lord.
Refused.
In this matter, I am led by Mr. Arindam Banerjee. He went for the blood test, my lord. He said,
Thank
if your
God.
lordship,
Otherwise, it would.
he said, if your lordship, my lord, kindly accommodate today, my lord.
Expeditious hearing.
I will do it, my lord. Otherwise,
Para 34 kindly sees that is the grievance.
Para
Mallet,
34,
Mallet,
page 14.
this is a application filed before the.
How long is it pending? 2012?
But 2012.
What is the stage?
Stage is a final argument.
You must have taken time.
No, Mallet, this is.
You have annexed anything? This
Yes,
order
Mallet, I
sheet?
have annexed file. Kindly see page number 290,
Mr. Khalid, have you checked up the order sheet? Did you get the time? No.
199.
4 years, no.
Did they take time on many occasions? If not, then we'll
199, Mallet, kindly see.
we'll direct it to
Make sure.
dispose of within what could be a reasonable period, Mr. Khalid?
Mallet, earlier it was order was passed by this honorable
Next
court.
date is
Kindly see
on
page number 205 once.
Next date
205.
is 8 January 2026.
214 is the last order.
205, kindly see.
Now, 214 is the last. Thereafter, I don't find any. 214, volume 2. 12 June 2025.
Mallet, there is a direction to dispose it within 2 months, Mallet. 205, last paragraph, Mallet. Already, Mallet, there is a direction, Mallet.
We understand they are hard pressed, but since there's a direction specifically,
And I, Mallet, mentioned for preponement, Mallet. But, Mallet, that was denied.
no, we'll direct that.
That specific time limit, Mallet, so that.
The grievance of the petitioners is that OA 663 of 2012 bracket LRTT has been kept pending inordinately by the tribunal despite a previous direction of this court dated September 26, 2022, whereby the tribunal was requested to take up the matter on the next date fixed, that is on December 5, 2022, and endeavor shall be shown to dispose of the same within 2 months therefrom, after affording an opportunity of hearing to all the parties and by recording proper reasons in accordance with law. Push up next para. However, unfortunately, in the teeth of the said request of the coordinate bench dated September 26, 2022, the matter is still pending, although we are in the month of August 2025, that is almost 3 years thereafter. Full stop. Accordingly, WP LRT 119, 119 or 119? 119 of 2025 is disposed of by directing the West Bengal Land Reforms and Tenancy Tribunal to dispose of OA 663 of 2012 within bracket LRTT positively within September 26, 2025, without granting any unnecessary adjournment to either of the parties by preponing the date next fixed for hearing of the same. Push up next para. The tribunal, for the purpose of compliance, shall act on the server copy of this order without insisting upon prior production of a certified copy. Full stop. The petitioner shall communicate a server copy of this order on the tribunal as soon as the same is available on the official website of this court. Full stop. No rest to cost.
Deeply.
Thank
you. Affidavit of service.
Yes. Next.
I am appearing
Yes.
appellant, Malad.
Yes.
Appellant applicant, Malad. This is an application by the appellant for restoration of the.
This is the default. File within time. Within time or beyond?
Within my knowledge is.
No, not knowledge. Date of.
Was dismissed on 3rd October 2022. My client is residing at Mumbai. And my knowledge about this dismissal is, I have stated that paragraph.
This was after admission?
Yes, Malad.
No, not dismissal. It was held to have abated.
Abated in respect of respondent number 1. And in respect of respondent number 2 is concerned. Since
so what about the abatement? Have you filed an application for substitution after sitting as a
candidate Mr. Mahato Junior was represented for the 1. But thing is this is a
the abatement remains, but regarding the dismissal.
In regard to 1, in regard to 2 is concerned.
The appeal had already been admitted.
Yes.
Then what was the occasion of coming up before the division bench?
I should not make my comment. But, I was not represented, but the respondent was there. Lordship will find from the record.
You should give a copy on the advocate for the respondent.
Respondent, since one is abated, he refused to accept the same.
File an affidavit of service saying that.
Yes.
In your affidavit of service, say that he has refused on the ground that it has abated.
I will make another endeavor to serve him.
No, the advocate.
Advocate, yes. I will,
No, when did he refuse?
I have to take. Just after 5.
Whoever went to serve him, your clerk or somebody, he has to affidavit of services.
Initially, it has not been endorsed by refusing, but orally he is saying.
No, oral. Your clerk has to file that affidavit of service stating that. He has to affirm that I went to serve, orally refused. Say that and we'll take.
Yes,
Then we'll put it on Monday.
On Monday, instead of Monday, Lordship will fix it on Wednesday.
No difficulty.
There is a client's personal difficulties.
Very well.
Brother-in-law is.
No, your clerk has to affirm it.
He is in hospital too. And
Clerk?
Oh. That is the difficulty.
No, so when should he keep it? Tell us.
Be on Wednesday, subject to your Lordship.
Yes, absolutely. A copy of the application be served on the learned advocate who had appeared on behalf of the respondents, and an affidavit of service to that effect shall be filed on August 13, 2025, when the matter shall next be listed under the same heading. Make a truthful attempt to serve.
One thing is that is also astonished to me. After admission in second application.
Yes, our officer also pointed out, and she rightly pointed out to us.
I should not have.
No, that will be one of your grounds because you missed it.
And I should not say anything about this.
No, that can be one of the grounds why you missed it, because you are not supposed to look at the division bench.
Of the procedure.
Very well. Remind us when you take up next. Pass over question only. You are there. Yes.
9-10টা হয়ে যায়
ছোট ম্যাটার
Mr. Chakraborty is there.
আছিস
It is in the next matter. Let us hear this matter till the rest of the day.
Yes, ma'am.
Yes.
Item number 9, my lord, only thing is this, there is a stay. Only there is a stay, the appeal has to be heard. Your lordship kindly fix the matter for final hearing of the appeal. My lord,
Item 9.
Item 9.
9 and 10 together.
There are two appeals, my lord. I am just giving the number. One is
9 and 10 আর অ্যাপিয়ার পাসওয়ার্ডটা ডেকেছে দাদা
পাসওয়ার্ডটা জোসেফ নিচে item number 9, my lord, you lordship kindly consider there are
For
two
the other
appeals.
side in 9.
Lord, I'm there. Lord, for writ petition or respondent.
What is appearing? Why is it appearing as an
Lord,
application?
there are two appeals filed by my lord senior friends. Lord, they filed applications. But the last order, my lord sees the honorable division bench presided by my lord Justice Chakraborty, my lord. Their lordship was of the view that there is an interim order passed that they will not deal with the property.
Appeal application together.
Appeal application together would have been heard. Paper books have been prepared. My lord, paper books have been filed also. So my lord may take it up any time, lord, whenever it suits your lord.
আচ্ছা 9টা একবার দেখে না এই অর্ডারটা পাস করে তারপর 4 এ চলে আসি। We are calling for Learned counsel for the parties submit that the appeal and the application were supposed to be heard together as per the previous direction of a coordinate bench. Full stop next para. Accordingly, let the appeals and the applications be listed under the heading hearing on August 11, 2025, Monday.
Lord, the paper books have already been filed.
We'll take
Monday, my lord, I have an RCT is going on. You lordship kindly give me RCT treatment is going on 10 days, my lord, kindly give me. In the meantime, it will.
Why did you rush in and?
That's why tomorrow I shall they will not be there. If it is called tomorrow, then I have some problem. I have to go there. My lord.
Tell us when you will keep it. Your appeal.
Absolutely, lordship. After 15
no, your
days,
appeal, but you are enjoying a status quo order.
Yes.
After 15 days, I am just. It is just appeared today for the first
15 days.
15 days.
Whenever my lord, my lord may keep it on 21st. Whenever your lordship's diary will permit, we'll not argue the appeal.
Listed on August 11 na kore August 21, 2025.
Absolutely, grateful to lordship.
Lord, it would appear in the heading application only, not because
hearing. How many hearings are there in our list? Show him the list.
Suffering from a terminal disease. May I get some?
Show him the list, please. Just show him the list. Yes.
চলে আসবে এর মধ্যে in between some matters will come. Lord, he is suffering from a terminal disease. Not only if something could be.
We call on the passover matter. 4.
I am for the petitioner. My lord, before inviting my lord to the impugned order of the land tribunal, my lord, it will be better if I state the my lord fact in a 2 and 3 sentence. My lord.
Absolutely, yes.
Yes, my lord. But petitioner, after satisfying the registering authority regarding the title.
You are for the Bankura municipality, obviously Bankura municipality. Please take your seat.
Right. Petitioner, my lord, after satisfying the appropriate registering authority, my lord, regarding right title interest of the parties, have by several sale deeds, my lord, purchased certain lands. After purchasing the lands, petitioner approached the BLRO, kindly muted my name in respect to my lands. BLRO did nothing, my lord. Rather, my lord,
State should be represented. Mr. Dhod was there. Where is he?
On earlier tomorrow, yesterday is there, my lord. State appeared, my lord. I have served, my lord.
They are the main contesting party.
My lord, kindly see the order of yesterday's order, my lord.
Yesterday order says Bankura municipality paid for time.
Yes, state was there, my lord.
State was there.
Yes.
Today is not yesterday.
No.
State is not there. That is what we are saying.
Yes.
State is the main opposite party, the respondent. What is your relief sought?
Now, my lord, after purchasing the land, I approached.
You sought mutation, not granted.
Not granted, rather erroneously my name has not been recorded in respect to my land. Rather, erroneous recording has been done.
What, in whose name?
Erroneous, my lord, Rajiv Goenka, the respondent number 7.
Who is he?
My lord, private respondent, I have served, duly served.
Private respondent.
But
he purchased he sold the property to you? Or
No. I have purchased from the, my lord,
from the vendor.
Vendors.
And vendor sold to the purchaser.
No. After purchasing my land, I approached.
Is this Rajiv Goenka?
Rajiv Goenka, outsider, my lord, outsider.
You served on Rajiv Goenka?
Yes, definitely.
We should hear him before.
Yes, I have served, my lord. I have affidavit service is there, my lord. Kindly see. His name, my lord, erroneously been recorded by the BLRO. Now, my lord.
Now, why refused?
Now, my lord, I have made a representation before the BLRO that has not been considered by the fact-finding authority. Now, my lord, I approach before the tribunal by preferring the OA. And with a prayer, kindly direct the BLRO, the fact-finding authority, before whom my representation pending, to dispose of the representation after hearing me and by passing a reasoned order. That has been, my lord, dismissed. That
very intricate question of law.
No, my lord, the question is.
Why did you waste so much time?
No, that is, my lord, necessary, my lord, because, my lord, the order, kindly come to the impugned order, my lord. I am reading, my lord. Heard the both side, peruse the representation.
Your
and
prayer is for consideration of the representation.
Yes, my simple prayer was that. But, my lord, the
why past tense? Now, the same prayer now also.
Same prayer now also. Because, my lord, the tribunal, my lord, erroneously, my lord, opined, we find sellable right of the vendor has not been established.
Given a representation, let that be considered.
Yes.
The toughest order for us to pass.
That is a simple prayer, my lord.
Direct that. Yes, we will direct. Affidavit of service filed today be kept on record. Despite service, only the Bankura municipality respondent.
I have no role to play, my lord, most probably.
You are?
My lord, I have no role to play regarding mutation.
No, only the Bankura municipality respondent is represented today.
Because, my lord, tribunal asked us to implead them as a party respondent. That's why.
Next para, learned counsel for the Bankura municipality submits that the said municipality has no role to play, which is quite correct in the circumstances of the case. However, in view of the innocuous nature of the prayer, no further notice is being directed on the other respondents. The simple grievance of the petitioner is that the petitioner, after allegedly having purchased the disputed property, applied for mutation thereof in her name. However, the concerned authorities sat tight over the matter. Thereafter, the petitioner was constrained to move the tribunal to have a direction which was refused, prompting the present application. Next para.
Representation is at page number 24. 17th October 2022.
Upon hearing learned counsel for the petitioner, WPLRT 116 of 2025 is disposed of by directing the respondent number 2, that is the block land and land reforms officer, Bankura -Roman 1, to dispose of the representation of the petitioner annexed to the present application as annexure P3, as expeditiously as possible, comma, if necessary, after giving opportunity of hearing to all if necessary, after giving opportunity of hearing to all concerned, comma, including the petitioner and the respondent number 7, and decide on the same by a reasoned order as expeditiously as possible, comma, positively within 6 weeks from the date of communication of this order to the respondent number 2. Full stop. The parties and all concerned shall act on a server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy thereof. No rest.
Imputed order set aside, my lord. Otherwise, my lord, the saleable right has been questioned here. My lord, where, my lord?
It is made clear that the observations made by the tribunal in the impugned order shall not adversely affect any of the parties in any manner, in any proceeding whatsoever, before any forum / court. Next. Thank you.
And for the respondent, your lordship.
Review.
Yes, your lordship. This
Petition.
is that matter, my lord, where your lordship remembers we had filed a suit for declaration and injunction challenging the disciplinary proceedings of the employer and including the HR manual, my lord. Your lordship thereafter had passed an order, my lord, in our favor and had referred it to the trial court, your lordship.
So they have to be present if they are not there. You are for which respondent?
I am for Ashim Kumar Samanto, your lordship. There is only
one. Yes.
One
Plaintiff respondent. Although the plaintiff / respondent is represented through counsel, none appears to move the review application. Full stop. Accordingly, let the matter stand adjourned for the day. If you can, please just inform Ms. Lala, the other side, that we took up the matter.
Yes,
not
your
taken.
lordship. Yes, your lordship.
Give your names, whoever is appearing with you. Yes. You are left-handed.
Yes, your
We did not know that. Yes. Next. What?
But in this matter, I am appearing.
Petitioner.
Yes, petitioner.
Right.
I appear for the respondent state. This is my affidavit of service.
All have been served?
Served.
Yes. What is the matter?
I cannot say that service. A very short point was involved in this matter. Respondent 8 in the writ petition was served.
Wait, we have a
actual
only the cover for the yes. Now we have the
yes, 8 and 9 I have served.
You are for 8 and 9?
No.
You are for the state.
State.
Please take your seat. I will just hear him. Yes.
Well, the point is this: I am a recorded owner, a portion of a land, and that portion of land conversion was made. But the Panchayat authority
demarcated portion or share
of the portion, that is the on the basis of the conversion, by the order of the conversion, it must be demarcated.
Achha.
As far as I
please just take the microphone a bit closer to you. Turn it like this.
Yes.
Take it towards you.
Yes. I am a recorded owner.
No, we have heard what you have said.
Yes. And after conversion,
it had to be demarcated, converted.
Converted. But the Panchayat Samiti, he had the authority of the Panchayat Samiti, one of the co-sharer donated of his portion of land, that is 167 square feet.
Donated means by virtue of a deed.
By virtue of registered deed, 167 square feet.
To you?
No, my lord, the Panchayat Samiti, by virtue of one of the co-sharer, his share donated to the Panchayat Samiti.
Achha.
And on that basis, Panchayat Samiti constructed a public waiting room on the plot of the land. He has donated 167 square feet, but according to report, as per order of the Honorable High Court,
yes,
and the measurement was present in presence of the SDO and others officers, that is, he has constructed the house, that is 341 square feet.
So encroaching your land?
Encroaching my
your
land,
portion.
your portion.
The 300?
341 square feet. He has donated only 167 square feet, but constructed 341 square feet in this plot of
So what did you
respective
do then?
plots of land.
Then what did you do?
Then 174 square feet, that is the excess portions, without any following any procedure of the acquisitions.
Right.
And as a result, in the front of my plot, that is the public road, that is the road, that is the contact to Rasulpur road. One side.
It belongs to whom? Highway authority?
No, no, no. That is the public road, that is that road, there is question, but my ingress and egress, that is affected from the, that is the road which was going before in front of my land. As a whole, I am obstructing from
No,
ingress
your ingress and egress has been obstructed.
Obstructed.
Your portion, your share has not been encroached upon.
Share have been encroached because in front of my public waiting room was constructed.
No, in front of your house, waiting room is constructed is something
but-
else. That's your ingress and egress being. Was the encroachment, this 174 square feet encroachment, also encroached a portion of your owned property? Or it was in front of your property?
In front of my property.
So your property was not encroached.
Your property also encroached. In front of my, that is the 164, that is
Front of my property is not my property.
that is not my property.
That is not an encroachment of my property.
My property. That is one aspect. But in the conversion report, that is, it is the land was conversion in a particular portions of this land. On that front, that was
Conversion was permitted with respect to what portion?
that is the portions of the land. That is
What is the measurement of that?
measurement, that is 2 decimals of land. That is the total plot.
What is
number.
the
Well, I am going.
what does it come to? How many square feet? 2 decimal? Acha, very well. You finish your submission, then we'll ask.
That is the plot number 117. That is 3 decimals of plot of land. I became owner of the 2 decimals of land by different 3 deeds. And that is the rest portions of the one of the butter plot, that is also a plot number 117.
Now, what is your present grievance?
Present grievance, without any acquisitions, without any following procedure, the Panchayat Samiti is not permitted to construct which was not donated of his land. That is the admitted position by their own measurement. That is 174 excess land that was constructed. Either due process of acquisition, because he is entitled, he is a co-sharer. For this reason,
That's an allegation of encroachment.
Encroachment without
Encroachment of public land.
Encroachment for a waiting room, for construction
Whatever
waiting room,
purpose.
my property.
Encroachment on a public land.
No. That
On
is the
your land.
That is the personal property of the land.
Isn't it a civil dispute?
Well, kindly, sir, but the measurement was report is this. My look, straight way come to, that is the measurement report. That is page 154. That is the reference, that is plot number 117, 0.3 decimals, but actual area is 4.86 square feet. 117, 1183, that is 0.1 decimal, that is 1.096. That is their case is this, but the waiting room constructed area on road, that means the in front of the Kontai and Rasulpur road, in this case map. Road 109 square feet. That is waiting room area 450, on road 62, 109 decimal, on plot number 117, that is 341 square feet. And my lord, the excess land, concrete road, that is 747 square feet, and the butter plot 117, 1183 to 85. The excess land that was constructed by a road. For this reason, at the present moment, they have constructed in plot number 117, out of 3 decimal.
This is the correct approach. The learned judge, single judge was right. Civil court should decide.
Civil court, after
that is exactly what we held.
After measurement of their own
it's an allegation of encroachment at the end of the day.
Encroachment, that is the co-sharer problem.
So it's a civil right you are claiming that a portion of your plot has been encroached.
Even if that is not my portion, even if other co-sharer problem,
you have to take a stand whether it's your portion or
that is
not.
My lord, whatever maybe they have stand, they have encroached the excess land without any acquisition.
That's not your lookout unless you say it's your land or
This-
public
this is-
land.
This is also my land. In plot number,
So
I am.
you
I
are
am
saying a portion of your land has been encroached.
portion, that is not full portion, because the plot.
If your land has been encroached,
one
you
was
have to approach the civil court for a decree on that. And if your allegation is a partially, it is encroachment of public land,
No,
you have
public
to
land,
approach.
This is not a public land. One.
You said public road was encroached.
Public road not enclosed. Public road, that is the plot. That is the 10 square feet.
You are saying that your land, partially your land has been encroached.
No, my lord.
What is the?
I am not correct, my lord.
You're not.
Not, my lord. Kindly see 117. That is the personal land. Totally 3 decisions.
Personal, whose personal?
That is among the co-sharers.
Among your co-sharers,
Yes, co-sharers.
including you?
Yes.
So your co-sharer, your land means not only your exclusive. The co-sharer's land that has been encroached. That is your allegation. As co-sharer, you are entitled to every inch of the property, so you have a right to maintain a suit.
Yes. My lord, for this reason, I am entitled for compensation. For this reason, I am entitled. That is the admitted position 117 plot number. That is encroached.
If there was an acquisition, you would be entitled to compensation.
Compensation.
There is no
without any
acquisition, as you are saying.
Yes, without any acquisition, they cannot allow to construct. That is 174. Beyond that,
It is not their case that there is acquisition. Their case is that they were gifted and they have constructed. They have not requested.
Yes, they are allowed to construct only 165 square feet. But
Their
admitted
case-
position.
Let us just try to make you understand.
Yes.
Their case is that you are saying that you are co-owner of a property.
Yes.
That property has been encroached beyond the property gifted to them.
Yes.
That is your case.
Yes.
If that be so, then your case is encroachment on your property. Your means all the co-owners' property. This is your case, which has to be decided by a civil court, because they say they dispute and they say no, a portion was gifted to us. We have constructed on that.
No, they have not.
That is the case before the single judge.
Their case is this. They have constructed. That is the admitted position 341 square feet.
It is the firm contention of the state respondent by making affidavit that they have never encroached any plot of land.
Of the petitioners.
And further contention of state respondent that they have constructed public waiting room beyond the area which was gifted to them, but it is over the excess plot of land which do not belong to any of the co-sharers. Now, therefore, they say that they have constructed excess land, but not over your property. So you don't have a locus standi.
No, my property, 117.
If that is the dispute, they say they have not encroached upon your property.
No, that is not demarcated. They are their own sketch map. They have said they have encroached 341 square
The
feet.
dispute is that they say they have constructed on land excess over and above what has been donated to them.
Yes.
But they say at the same time that excess land which they have encroached does not belong to you or your co-owners. That is the stand taken by the state. Let us complete 2 sentences. After that, you will submit. That is their stand. Now, you say, no, you have encroached my portion also.
Yes, because
If that is the dispute, that is a precise dispute which has to be decided by civil court by taking evidence. And the learned single judge was justified in saying that you go to the civil court.
Well, kindly allow me. 117, that is the plot of the land of the owner of the all co-sharers. Nothing more, nothing less. No other person. One of the co-sharers gifted his share 167 square feet. But he had constructed 341 square feet. That is the excess land. That means other co-sharer land that was encroached. Their own sketch map. Their own sketch map, they have encroached 341 square feet. That is in plot number 117. That means other co-sharer land must be encroached.
Who are the other co-sharers? You are not one of the other co-sharers.
My also. That means my plot.
So your allegation is that they have encroached upon your land?
Yes. Encroached land, their own.
Who is to decide that? The writ court?
No, my lord. Their own measurement report. That is report was filed, my lord. That is not my report. That is the report of the my lord. Says my lord, that is the BLRO report. What says my lord? In the civil court, it will be decided which plot of land. That was decided by the BLRO. That is 341 square feet. That was encroached.
Achha, this BLRO report is a part of what?
That is that their oppositions they have filed. Encroached the all documents, my lord.
Which portion is yours in page 154?
154, that is the back portion. That is the entire 2 decimals of the land.
The shaded portion belongs to whom?
That is the waiting room.
That is the
Waiting room.
waiting room.
That is the waiting room. He has gifted one of the co-sharer only 167 square feet. But admitted position, they have constructed in plot number 117, that is 341. That is must be one of the co-sharers. That is not the other.
So you say, why should you be relegated to the civil court? They have to remove
They
it.
have to if he is permitted to construct by under the Panchayat Act, my lord, by acquiring this property, he will be entitled for construction. That is not a dispute that they have not constructed. They have constructed.
Construction is not disputed.
Dispute. But
They
the-
dispute that they have constructed on your property. That is just
my property means
what? No, no. By affidavit, they have stated with the single judge has recorded.
yes,
No,
yes.
no.
In plot number 117, only 167 square feet he is the owner. And I and other co-sharer are also owners.
Total plot number 117 is owned by the co-owners.
Owned by the co-owners. State government is now the one of the co-owners. He is constructed.
Right.
He is constructed.
One of the co-owners.
Co-owners. He is constructed. He is allowed to construct only 167 square
But
feet.
see, there is a doubt whether he could construct over a particular portion, because if the property is not partitioned,
Yes.
then
that means all. That
then
means
everybody is the owner of every
yes,
part.
yes. I have.
So even if the gift deed was executed in their favor,
Yes.
the one of the co-sharers could not gift a particular portion of the property.
Yes.
So that construction is illegal. But these questions have to be resolved by a civil.
I am not asking state is permitted.
You cannot pick and choose what you are disputing and what you are not.
Yes, yes.
You have raised a dispute
Raised
that
it.
whatever points are involved in that dispute, we have to see which authority can decide that.
My lord, I am only disputing without any accusation beyond his gift deed. State government is not permitted to construct.
Acha, yes. What
For this
is your stand on this?
But kindly allow me for a moment. That is the admitted position by their PLRO.
We'll continue tomorrow. We have another bench. There is a debate. Although the hearing was commenced, we cannot conclude the same, and accordingly adjourn the matter till tomorrow. Full stop. The affidavit of service filed today be kept on record.
Yes.
We'll come back tomorrow.